Ceremony will take place in a short while from now. Please switch off your mobile phones or put them on a silent mode. Swearing in ceremony being an official function, there shall be no clapping after the ceremony is over.
You don't have it.
Somebody asked for आपकी अदालत and those have two rights. I have two rights. But what both of them are more happy than your own having. E-lobby का एक बजे का
May I have your Lordship's permission to commence the proceedings? Communication has been received from Honorable the President of India. The communication reads as follows. 3rd December 2024, 12th Agrahayan 1946 Shaka. In pursuance of the provision contained in Clause 6 of Article 124 of the Constitution of India, I, Draupadi Murmu, President of India, do hereby appoint Shri Justice Sanjeev Khanna, Chief Justice of India, as the person before whom Shri Justice Manmohan, Chief Justice of the Delhi High Court, shall, before he enters upon his office as a Judge of the Supreme Court of India, make and subscribe an oath or affirmation according to the form set out for the purpose in the 3rd schedule of the Constitution of India, signed by the President of India. Warrant of appointment of Honorable Shri Justice Manmohan reads as under. By virtue of the power vested in me by Clause 2 of Article 124 of the Constitution of India, I, Draupadi Murmu, President of India, do hereby appoint Shri Justice Manmohan, Chief Justice of the Delhi High Court, to be a Judge of the Supreme Court of India with effect from the date he assumes charge of his office. Given at Rashtrapati Bhavan, New Delhi, this 3rd day of December in the year 2024, 12th Agrahayan 1946 Shaka, in the 75th year of the Republic of India, signed by the President of India. May I now request Honorable Shri Justice Manmohan to take oath.
I, Manmohan, having been appointed
a judge of the Supreme Court of India,
having been appointed a judge of the Supreme Court of India,
do swear in the name of God
do swear in the name of God
that I will bear true faith and allegiance to the Constitution of India as by law established,
that I will bear true faith and allegiance to the Constitution of India as by law established,
that I will uphold the sovereignty and integrity of India,
that I will uphold the sovereignty and integrity of India,
that I will duly and faithfully, and to the best of my ability, knowledge, and judgment,
that I will duly and faithfully and to the best of my ability, knowledge and judgment,
perform the duties of my office without fear or favor, affection, or ill will,
perform the duties of my office without fear or favor, affection or ill will,
and that I will uphold the Constitution and the laws.
and that I will uphold the Constitution and the laws.
May I have your Lordship's permission to conclude the proceedings?
The court will assemble for regular work at 11:50.
Please, Your Lordship, seek your permission to mention a matter. Connected matter is coming before Your Lordship on 10th. The other essay, civil appeal, despite being,
Don't you move an application?
I've done everything, Your Lordship, but they are saying without your instructions, they want 2
No,
weeks.
but move it, it will come before me, I'll pass the order.
Lordship, it's coming on 10th. The connected matter has to come along.
Please, I've said, just move a letter.
Huh?
It'll come up before me in lunchtime.
Much obliged, much.
Don't mention it, please, until unless there's some real issue.
I apologize.
With your lordship's permission, may I mention a matter of great urgency, my lords. My writ petition is scheduled to be listed on 9th. It's writ petition seeking direction to the Allahabad High Court to hear my anticipatory bail applications. They
I've
were
already
listed
passed
at,
an order. I've already passed it.
my lords, all I praise for is,
Please do not mention your letters have
my
been.
lords, there's a peculiar situation. Kindly indulge me for half a minute, my lords.
Please, not required. The letter was circulated. I've already.
My lords, my marriage is scheduled on 8th.
Yeah,
Matter
maybe.
is coming on
Maybe.
9th, my lords. It will
Can't
be
be helped.
infructuous.
Can't be helped. Will come up.
My lords, I've sent the email twice.
I'm aware of it. The date of filing I've seen your thing. It will come up on the day fixed. I've already issued.
My lords, interim protection may kindly be.
Sorry, not like that.
My lords, may I be permitted the liberty of making amendments? Lords?
No, please, we don't allow mentioning normally by letters.
I only wanted to say, my lord, that it's a matter of great urgency, which is linked to item 7 today, that SR Steel, ArcelorMittal, there's a clause
Whatever it is,
for.
we'll see when it comes up.
So we send the email, my lord, if you'll also make.
Please wait till the matter comes up.
Very well.
Is anybody there in item 43? It's a fresh matter. We'll take it up at 2 o'clock. Being a fresh matter, we'll take it up. Yes, please.
Please, my lord, by this petition, my lord, I am seeking transfer of the,
Are you working?
my lord, I am working and the respondent is working in
1 minute.
Delhi.
Husband is working in Delhi.
Yes. My lord, can
Wife
you
is working in Bengaluru, like they have concealed.
an actual.
1 minute, please. Is the husband working in Delhi?
Yes, my lord.
Yes.
Then what's the harm?
My lord, the wife is working in
But
Bengaluru.
doesn't make a difference.
Hapod is only 1 hour journey. My
1 minute, please. If you're staying in Delhi,
lord, pleadings are completed, my lord. My
that
lord.
will be dealt with in Delhi. Allowed parties to appear before the template order. Parties to appear before the transferee court on 8th of January 2025. Yes, please.
My lord, it was referred for the settlement. We have already sent various intimation for any proposal, but they have not come for any settlement.
Exorbitant amount lots for 12 lakhs loan. I received the offer for 19 lakhs lots. And he has already paid near about 10 lakhs lots.
I have also.
Yes, lots.
No, but why? We are concerned with the transfer matter. So I don't see any reason why the transfer application should not be allowed.
My lord, actually, in Calcutta,
You may present the check wherever you want.
no, but my lord, my normal practice that all clearing.
Please don't have that normal practice. Go away with that. Don't harass people. Allowed parties to appear before the transferee court on 22nd of January 2025.
I'm seeking the exemption of that witness.
Yes, that will pass.
My lord, in this matter, lordship, on the last occasion, your lordship granted a stay subject, and both the parties made a statement that they are willing to settle the matter.
I know, but we can't force them into a settlement.
Lordship, after making a statement, they are willing.
No, we can't. Statement means that there has to be consensus on the amount payable. Can I tell them to pay this much amount? Force them to do it? Answer is no. You figure you gave of 19, he says 19 is too high. I've already paid 10 lakhs out of 10 lakh loan. If I pay 19, I'll be landing up paying about 2 times the amount. I can't force him. I'll be concerned with the transfer app.
My lord, may I request one thing, lordship? If the matter may be referred to Supreme Court Mediation Center, where both the parties can appear virtually.
No, that request will be mentioned over, got it there in the order itself. Just mention. We'll record your statement that to the extent that the bank where the check was deposited and the memo issued by them is not disputed by. That we'll have to record because the bank will not be able to travel all the way. Just recording that. That the petitioner, however, will not dispute the factum of presentation of check as well as the memo issued by the bank of the respondent. Next case, please.
It's in item 3, I'm appearing for the petitioner's minutes.
It's appearing for the respondent. Yes, what do you say?
Marriage was so night, Saran district.
No, but she's now staying here.
She frequently visit Lordship, native place.
No, they could come here to make a difference. Allowed artist to appear before the transferring court on 22nd of January 2025.
Much obliged.
Yes, please.
I was assisting your lordship. I am of the respondent.
Just one minute. Wednesday rather than today because it's a part of it matter.
Can I only make one day? Can it be Tuesday, Wednesday? I know normally. Okay, I'll be there.
This next Thursday.
We'll show it. No, we'll show it. Those, my learned friend had said she had some examples. If you can give them to me, I can have a look at them.
Yes.
We have made examples. We've also
mailed it.
Lordships told us to get examples. We've got it, and I've circulated a copy to my colleagues.
So placed on record.
Not placed on record.
Please give it. Please give it to us.
Hand over, my lords.
Yes, please give it.
My lords, we'll just give to the courtmaster. There are two categories. One will be of inspectors. One will be of pharmacists. These are the only two posts which are involved here. Given to sets.
This non-functional grade upgradation
Yes, my lords.
must have come up before some high courts also.
We have a whole compilation of judgments. Shall I circulate it earlier? We'll do it. I have a soft copy. I'll circulate it earlier. Or if your lordship wants hard or soft, whichever way, we can do both.
You just give us the list or the ratio. Look, most of the judgments, 50% of 60% is just the arguments and the facts.
I will do it.
The ratio, that's all.
We'll give the judgment with a 2-page note on top giving the ratio. We'll do that.
It's because the first one was Chandrasekhar.
After Mohan, not before Mohan. After judgments after Mohan.
After Mohan.
Yes, after Mohan.
Not before Mohan.
No, after Mohan.
After. That's no problem.
There are two sets. There are sets.
Please say.
Lordships. Inspectors has 45 respondents, so inspectors list is bulky. Pharmacist is only one post, but I put the OMs along with that so that I've mentioned in the chart which OM, what is the issue.
Ashwara, can I also get a copy?
Yes, sir.
This is conversation. That is.
I'll get it done. I'll get it done.
Grateful, Malats.
Great. ये कॉपी करा के गिरी साहब.
Item 5, I have.
Yes. Any breakthrough?
And I was humbly praying, Malat, if Malat can reduce the amount to Malat 12 lakhs, Malat had said 15 Malat. He retired in 2016 Malat.
So pay 15, right? Pay 15.
They state certain facts.
We are not going into facts anymore.
On amount part, they are trying to reduce it on that point. He was in Coal India, thereafter joined TCS, suit property.
For 3 lakhs, don't spoil your life.
Malat, on 21st, Malat, let the parties appear before the.
No, we are just asking her to deposit and she'll withdraw. She has to move out by.
Yes, 4 months, my lord.
No, not 4 months.
Some time may be given.
Okay.
I have to
Okay.
clear out all my belongings.
Okay. We'll give you time till 29th of February. That's fine. Now you get virtually for 3 months. But that deposit will be only made on, by 15th of, or on or before 17th of February.
17th of February before the executing court money.
Yes, you deposit by 1st of February because she may require that money.
But it may be.
And she have to file an undertaking in this court that you will vacate by that day. And on breach of undertaking, the contempt will follow.
Transfer to my account, I will file affidavit.
But file an undertaking before this court.
By 20.
Otherwise, we are dismissing the appeal. Simple as that.
I'll file undertaking after deposit.
You file your undertaking within 3 weeks from today, that you will vacate by so and so date, and he'll withdraw. He'll give you 15 lakh of rupees, which you can withdraw after you vacate, or you can withdraw. But if you don't do it, then it will be contempt. We're making it very clear. Right on. We are not inclined to interfere with the impugned judgment. However, during the course of hearing, the learned counsel for the respondent, learned counsel for the respondent, Sandeep Datta, on instruction says that the appellant, what's her name? Shamli Datta, being her sister, he would pay her rupees 15 lakhs, but she must furnish an undertaking to vacate the premises on or before 29th of February 2025. Full stop. 28th of February 2025.
This year is
Last day of February.
Next paragraph. The counsel appearing for the appellant, Shamli Datta, states that the appellant will furnish an undertaking to the court to vacate the premises on or before 28th of February 2025. Full stop. Next paragraph. We take the statements made by the counsel for the parties on record. Full stop. Part. The appellant, Shamli Datta, will file her undertaking on or before 3rd of January 2025. Full stop. In case there is a breach of the said undertaking, she would be proceeded in accordance with law, including contempt. Full stop. The respondent, Sandeep Datta, will deposit rupees 15 lakhs before the trial court on or before 4th of February 2025. Full stop. Intimation with regard to the said deposit will be furnished to the counsel for the appellant appearing before this court. Stop. The appellant would be entitled to thereupon withdraw the said amount from deposit before the trial court. Full stop. The impugned judge, the appeal is disposed of. In case there is breach of any of the conditions, in case there is any of the parties do not abide by the statement made, it will be open to the parties to file an application before this court, including in case of breach of undertaking by the appellant, Shamli Datta, contempt proceedings.
I'm grateful.
The appeal is disposed of. Yes, please.
Note item 6. Your Lordship may kindly come to page.
We are dealing with that Sahara matter. We'll deal with it there. Why should we entertain us?
Your Lordships are dealing with SEBI versus Sahara. The other petition which is pending is at page 107, where the fund of 5,000 crores has come to this particular society.
In that matter itself,
yes,
we have directed payment of money also.
True. Now
we'll deal with it there, not in a separate by separate.
So no, Lord, the point is, Lord.
Why no? You please move an application in that.
I have absolutely no problem. Lord, Lordships will give me that liberty to move an application in the pending writ. Very, I have no problem.
We are not inclined to entertain the present writ petition. However, as the petitioner may file an application in the pending matters.
Which is not writ petition civic
I'm
one
saying pending matter.
Very well. Very well.
According to opposite, the writ petition is dismissed as not entertained without making any comments or merits.
Obliged.
May I please, Your Lordship?
Milord,
The first matter is
It's the interim order. Why
that's right, Milord, then the pending.
Why are you interfering?
Milord,
Please sit down. We'll call upon you when you require.
May I just address that straight away? Not under the IBC and a direct judgment of my Lord's Court, the moment the CIRP process is over, the plan is approved, the RP stands discharged with a specific order in this case.
1 minute. The issue over here is something, we are not concerned. That can be decided by the NCLAT. At this moment, only stay of certain proceedings have been directed. Stay of certain operations, stay of certain orders have been directed. What has happened thereafter?
I'm in the first matter. The first matter has a very straight legal point. What is the point at which the role of the RP comes to
1 minute, please. Mr. Gopaljan, matter is still pending before the NCLAT. Is that correct?
Yes, but the plan has been approved and
Maybe let them decide that.
No. This issue doesn't arise. There are 5 other proceedings, my lord, litigated all over.
Look, Mr. Gopal Jain, Mr. Gopal Jain, you are for the resolution application. Or erstwhile resolution application.
No. Resolution
professional.
My lord, my case is different. Just bear with me for
1 minute, Mr. Gopal Jain. You are for the resolution professional. The issue raised is relating to the costs which have to be incurred, which were incurred during the period before the resolution plan was approved. From the date of filing till the CRP process, there is a legal issue there that will be decided by the NCLAT.
I'm not on the legal issue with greatest of respect. It will now be a fight between the successful resolution applicant and whoever.
Let it be answered by the NCLAT.
I should be.
No, we are not deciding that issue.
I only want to say one thing.
Can I just finish?
Let him conclude first.
That's right. 2 years below.
Please sit down.
Milord, on 8th January 2020, by a specific order, I have already been discharged. Let
it be your discharge, whatever it is, you please say that before make the statement before them, that issue will be decided.
There are 5 other matters in which we've been dragged. Just bear with
Mr. Gopal Jain, it will be decided by the NCLAT. We're not coming to, we're not allowed to leapfrog and come here directly.
No, I'm not leapfrogging, your lordships. Just 1 page and I'm done. Just have page 274 and I'll leave it. Para 48 at page 274.
Yes.
The detailed provisions have been stated, make it clear that the resolution professional is a person who is not only to manage the affairs of the corporate debtor as a going concern from the stage of admission of the court till a resolution plan is approved by the adjudicating authority. My lord, once this is done and my lord's court approved the plan on 15/11/2019.
We are not deciding and determining that controversy, neither does the impugn order decide and determine.
It issues notice to me despite
Correct.
the fact I
doesn't make a difference, please.
Once
Impugn notice is not a cause of action.
Can I
Lord has
Please, Mr. Costa, wait for your turn.
I'm making one request.
Before NCLAT and he's not arguing all this.
Yeah, why are you arguing when we are not entertaining his plea? You want to argue still?
Milord, for your lordship, just do this. Record my statement that all these issues will be raised.
Correct. Yes. What do you say?
If your lordship is dismissing the appeal, I have nothing to say. But this is the collusive. Your lordship hit the nail on the head. This appeal is not really by the RP.
Why you want to argue?
I said, my lord.
I am the SRA. That correction only I wanted to say. I am agnostic whether your lordship hears it or there. I am the SRA. My objection is only one sentence. After your lordship, after the Supreme Court approves it, a claim comes for 1,300 crores.
Mr.
Which is not
Dr. Satpe, we are not determining, deciding any issue.
If I am agnostic,
Right.
Because the nail is already hit on the head.
Right. We are not inclined to interfere with the impugned judgments, which are in nature of interim orders passed on the date when the appeals had come up for hearing before the National Company Law after Tribunal. Full stop. These orders do not decide any substantive lists. Hence, the appeals are dismissed without examining the merits of any of the issues and contentions which will be raised before the National Company Law Appellate Tribunal.
Just one sentence, Milord. I have a cross appeal. I have a cross appeal that can be disposed of instead of dismissed because, Milord, I was under CR.
Withdraw.
Then in view of the order, I'll be withdrawn.
Would your lordship just record my one submission so that I can expressly raise it that by an order of 8 January 2020, we had already been discharged and this we can drop.
We are not saying anything more than this.
Will not allow us to raise your lordship.
Maloj,
Make it clear.
if I may just take,
raise it.
Maloj, just one concluding
My submission that I can raise.
Maloj, this fraud has been going on for the last 3 years. They're not allowing any court to examine. Your lordship may just kindly request NCLAT to dispose of the matter one way or the other within defined time.
That's fine. They'll take into account their work pressure.
No, actually, my lord, ArcelorMittal has successfully postponed this matter for 2 years because of this pendency. I'm glad that
Their
it
own
come to
appeal.
an end today, my lord. Deeply obliged.
Next case, please.
Mansullah,
May I please, your lordship?
Please will not come the affidavit by.
Drafters, your lordship just have it next week. I'll assist your lordship in this.
And this case reveals a lot. What is the problem with why this groundwater depletion?
I agree with this. I agree. No, I have only received.
And we are running after wrong people.
I agree with you. I agree, entirely agree with your lordship. There's something to be set right in this. As an officer of the court, I can tell your lordship, I have only received the draft last week. I was asked to kindly have
It's non-compliance of the order dated.
Your Lordship, if I may.
You are working, no?
Your Lordship, if I may, just one submission.
You are not working anymore. You don't want to carry on in the manufacturing also. That was what I was told some days ago.
I'm sorry, Your Lordship.
I was told probably you're not. Umang Dairies is no longer functional. It's not in operation doing manufacturing activities.
I will have to take instructions on that, Your Lordship.
That's what I will remember somebody told.
I'm sorry, Your Lordship.
That is what I remember being told in the court.
Your Lordships, I will have to take instructions from the client on this.
Instructions.
One more request, Your Lordship. In the previous hearing, Your Lordships had deliberated on the effect of shutting down of industries which are still undertaking steps to recoup.
I know that. The figure shows that they're not depleting the groundwater, but they are recharging the groundwater beyond what they are using.
Please, my Lord. Lord,
So by shutting them down, in fact, groundwater recharge will come to industry is not the main culprit here.
Your Lordships are absolutely right. If Your Lordship would allow, the appellant will be filing an affidavit.
File.
Steps. Much obliged, Lordship.
So strong. To 6%. So we run after them now. Plans, it's been a very long, we've given you a long rope now.
Lordship will issue appropriate costs. I can't defend this. So your lordship will impose some costs.
There is non-compliance of the order dated 26/7/2024. Stop it. View of the long delay, and as further the government is sought for, the cost of rupees 10,000 be paid by respondent number.
State of the five minutes.
Respondent number 5. Who are permitted, who must comply and file the affidavit within a period of 6 weeks from today. Pre-list on this list day, the week commencing February 24th, 2020.
Lordship had ordered me,
May
for the
please,
last
Lord.
order, he had given me.
I'll just,
Yes.
Lordship, if
Take
this.
instruction
if
from the
Lordship-
client regarding the presence of the relatives of respondent number 2. Yes, it is, and I have filed an application for permission to file an additional affidavit regarding this.
You are related to each other?
Oh, no, we are not related.
You are not related?
Not related.
Are you related to each other?
No, Lordship, I'll just put, they have filed that additional affidavit.
Yeah.
No, okay, look 1 minute. Everybody is related in that council to each other.
What I'm saying is this.
That way in a village.
If I may just place my case, there were two issues for which we came to this court. One was that I was denied the right of cross-examination. And secondly, the kebang was presided by his father and uncle. Those were the two precise issues. Now he has filed an additional affidavit, not denying the fact that his father and uncle were there.
They are correct, but he is also.
But he is also. So therefore, as an officer of the court, I must say that such a judicial proceeding cannot be approved.
No, please. Probably it's not possible because everybody is related.
No, Lordship, but then a father sitting over, and what about the right? I have been denied the right to cross-examine.
That's not required. That's not required.
Right to cross. He has.
No, it depends upon them.
These
are not courts which are where the Evidence Act of the CPC is fully applicable.
Yes, no, but then Lordship, there
the
has
spirit applies, not the letter of.
Lordship, may I just kebang proceedings are judicial proceedings.
Look, don't we decide writ petitions on affidavits?
We do, but once
do you
the
think
court
that
examines
those decisions are not good enough?
But once a court examines a witness, can I be denied the right to cross-examine? Lordship will kindly appreciate this is a valuable property. What am I saying? Lordship, but then I've been. It is on record. The court relies on the evidence.
136 to interfere. We are not inclined to interfere with the impugned judgment and especially.
Oblige, my friend. Very well, Lordship. Great.
Thank you, sir. This is the Lordship. So pleased to issue notice in March 2023.
Yes.
This is a case where both the trial court as well as a
first. Are related to each other?
All of them are related to each other.
Then how can he 1 minute?
I am his
eternal. Then the plea which you took.
Sorry, Lordship.
Then the plea which you took that please clear your title. Wasn't it make believe?
No, Lordship. The problem was defendant number 2, who's also related.
1 minute.
Yes.
You are related, you knew your inheritance rights of his side.
Yes.
Then your plea when he asked for the money, you said no, get your title clear. Isn't that make believe?
No, all we had said was that defendant number 2 is interfering with the title because of a subsisting dispute. Now, eventually, Lordship, this is a question of fact.
If you are related and so closely related, you must be aware of all the disputes.
Lordship, I'm only the nephew. This happened later. They are first. Your Lordship, this is a question of fact. Both the first appellate court as well as. Your Lordship, may I just submit, Your Lordship? This is a case where it's a finding of fact which on second appeal has been interfered with. The first appellate court and the trial court.
Yeah, the disputation on the one.
Lordship, may I just submit that one.
How much interest has been awarded for the fund of that?
Your Lordship, we have already paid money. May I just submit the second appellate court?
16,000 you paid, no?
In the trial court and the 24,000 we paid on the date of.
Withdraw that part.
We have not withdrawn.
You are not withdrawn. You are how much interest is? 1 minute. How much interest is to be paid on 16,000 which you paid you?
No interest was paid, my lords. He deposited.
1 minute, please.
Yes.
You had received 16,000.
Yes, my lords.
You
That was returned by DD.
That was returned.
Yes, my lord.
And that I'm sorry, Your Lordship. I'll just point out.
Okay, under protest.
No, Your Lordships. We didn't take it. We returned it. Number 1. Number 2, the remaining amount was deposited in court at the time of filing the suit in 1991 itself. And that is something which the High Court. And now the sale deed is registered in my favor.
Doesn't make a difference.
Today we're at a stage when the sale deed is registered because I paid the money and they've withdrawn.
So please, your whole plea with regard to when he asked for the money.
Yes.
Your whole plea at that time.
Yes.
We don't agree with the High Court saying that you have to show every day in, day out that he was ready and willing to pay.
Yes.
That is not the correct. That's the reason why we issued notice. That legal position is different. But the fact of the matter is, when you took up the plea, I'm not only going to pay. When you get your title clear, there was a sham and a bogus.
No, Your Lordship. If Your Lordship is your second letter I wrote at page 41, I said, okay, you fix a date. I'm going to pay you the money. Your Lordship, unfortunately, the High Court has not even seen that I've already deposited the money. Right now, the money is not lying with them.
That's your issue. Right now, we are not.
Lordship, it's pure finding of fact.
No, please. We are not inclined to interfere with the impugned judgment, and hence the special petition is dismissed. The petitioner will be entitled to withdraw the amount deposited by the for the trial court along with interest accrued if any.
I
The
mean,
respondent will refund rupees 16,500.
16,005 rupees.
16,005 along with interest at the rate of 8% per annum from the date of institution of the suit till payment is made.
Even the-
degree passed pursuant to the judgment of the High Court will be treated as modified to this extent.
Even the 24,000 is with them. We have deposited in court.
No.
Deposited in
That is
court.
No.
That's court, my lords.
Whatever, that will be paid
That
to
is
you. now.
deposited in court.
And your lordship will just say, if that has also been withdrawn, that will also be refunded with the same interest.
In
If that's been-
case 24,000 has been withdrawn by the respondent, they shall refund the same along with
Yes.
interest at the rate of 8% from the date they had withdrawn the money till the date of payment.
I'm
grateful.
Listen, Suresh, I'm for responding of 5 and 6.
May it please, my lord, appear for the state in this
I'm
matter.
victim of the false and frivolous complaint in this matter, and the Munadi was done, and each and every.
There's no women candidate will come. How can it be?
Yes, Lordship, I'll show the document. I'm showing. Show the document.
Concurrent findings, my lord, concurrent findings.
I'm showing the documents.
Do you think women in the country will not apply for such posts?
Yes.
Why?
I
thought they would be
two
very
ladies,
happy to apply for
two
such
ladies complained this issue, and documents shows. Kindly see the one document. I showed only one.
The findings are there. We can't go into all that.
To show.
Concurrent findings that there was no publicity carried out, my lord.
Already he's in difficulty. Why do you want to join in? When we put a question, you please join. When we are putting the other side into questions, why you answer?
My result is page number 6. Kindly see one moment only. Kindly see.
You see
because she respondent number 5.
Look, 50% seats are reserved for women, and nobody applies for a post of a teacher. What are you saying?
Way back in 2004. This lady herself in the village politics. This is a matter of village politics. Lordship, kindly see the page number 6 only. Munadi was done, Munadi was available, everyone is there.
You're not inclined
and
to
each and every forum
that's all
to me. Lordship is the last forum and there is no
That's
scope.
correct. We are the last forum and we should not interfere. And until unless there is some grave miscarriage of justice.
Kindly give me an opportunity to.
Sorry, no. We are not inclined to interfere with the impugned judgment and hence specially.
Grateful, my lords.
My apologies, my lords. I'm seeking a passover in the matter.
Come at 2 o'clock.
My lords.
One side.
Don't sit down. Here I might just indicate that at the stage of issuing notice, your lordships had required us to deposit 3 crores with the authorities within a period of 6 weeks. Just for your lordships to note that we have duly made that particular deposit. Now, I might indicate that I have two broad sets of grounds in pressing this appeal. The first set, which I will place before you, is with a request that this is really a case which merits a remand back to the National Green Tribunal, because there has been no meaningful consideration of our defenses, even though those are noted. 1. Number 2, there is your lordships have now held in a series of orders that it is for the National Green Tribunal as an expert body to apply its adjudicatory mind. And you can't just leave it to this committee and that committee and thereafter cut and paste those particular committee reports and then put a conclusion. The third point which I want to mention, before I get into the individual, I'll go individually on merits as well, if required to. The third point which I want to mention is that this is really a case or a situation where there was a initial application which was made by a certain gentleman. A second application was also made. In that first application, the court takes session of the matter, the NGT. it appoints committees. The committees conduct a series of site inspections, etc. They make reports, they require compliances. All those compliances are fulfilled. The case is closed by the NGT. The case is closed by the NGT. Then a petition which is pending, a second petition which is pending, is suddenly resurrected about less than 2 months after the NGT itself, a 5-judge bench of the NGT has closed the case in my case, after examining all the committee reports, etc., which has come. Then it appoints a fresh committee. And after it appoints a fresh committee, they get a series of reports, different committee, and then they say. So I'm going to also, I think this is a very important question of law, because in the public interest litigation area sphere, your lordships have held that the principle of res judicata, or an analogous principle to res judicata, does apply. You can't have people being vexed again and again and again after the whole matter has been considered by the very same forum in the public interest and application of mind, not some summary dismissal. So these are the broad heads. Then I will go item by item. For example, they have mentioned green belt. They have mentioned certain areas, satellite imagery, etc. If necessary, I will go into those items, etc. individually. Now, would your lordship, first and foremost, please may I just give you a few dates, and thereafter your lordships may just consider. Yes. So, there are two elements here as far as the key dates are concerned. This, just broadly note, we are concerned with mining of minerals, minor minerals and stones. Stone along with associated minor minerals. And we are concerned with an area of 48.87 hectares in district Bhiwani in Haryana. It's at a place called Dadam, D-A-D-A-M. Now just note that before I was given this, because there was an open tender, etc., there was a earlier person who also was mining in that same area. Just keep that in mind, because there are certain allegations which are made over here with regard to this thing. Now, my letter of intent was issued on 11th October 2018. 11th October 2018. This was, as I mentioned, pursuant to a tender. Mine was the highest bid. And I'll just give you, I was quite staggered by the figure, but I'll indicate it to the court. My bid, which was for which I got an award, was 92 crores and 12 lakhs per annum. These are 10 years. No? The term was for a period of 10 years. Next date you may notice that the lease deed is executed on 18th February 2019. The party, you may just note the name, the party who was occupying this broad area, because that was a larger area, same area of 55 hectares, was one Sundar Marketing Associates. We have no direct concern, but he was operating in the same area. Sundar Marketing Associates. Then I come back to myself. After the lease was executed, I got a consent to establish on 10th February 2019. I receive my consent to operate on 25th February 2019. And I commence operations, therefore, after 25th of February 2019. Now, the NGT takes up an initial original application. I call it the first original application, qua me. And that original application is numbered, please note the number, 132 of 2020. It's by one Rakesh Dalal. It was triggered by a letter of 8th July 2020. And I'll just give you one more date qua this application. The application came to be disposed of on 2nd June 2021 by the NGT. It happened.
Which page is that order?
Yeah, so I'll take you to that. It's page 100, volume 5. Should I take you to it right now? Yes, 100, volume 5.
Screen. Take this copy, put it on the screen.
Do we have an extra copy? Yeah. Well,
No,
have
we
at
can,
least one.
we'll have it on the screen.
I have one additional.
No, we have it on the screen mixed with it.
Whatever whatever the court like. I'm sorry about this.
Expand it a little.
Yes, I think they have produced it.
Clear cut. Yes. Yes, please.
So just, your lordships have it?
Yes,
Okay.
please. There is a
Yeah.
reason.
So
Which
I'll just now.
paragraph is the relevant paragraph?
Yeah, so I'll just, there's 3-4 things, correct? So please first note the original application number 132 of 2020, your lordship has that on top?
Yes, that we have seen.
And you have noted also Rakesh Dalal.
Okay.
Rakesh Dalal.
Page number?
Page
We got the file now.
I'm just giving you, just pointing out a few things. Oh, your lordships have volume 5. Oh, wonderful. So, my lords, if I may request you to go to page 100. Your lordships have page 100 now?
Yes.
Correct? So, just see the thing. Original application 132 of 2020, Rakesh Dalal versus State of Haryana.
Yes.
2nd June 2021, 5-member bench. And please see, my name is mentioned there. Application has been filed against illegal mining by Messrs. Govardhan Mines and it's the same party, right?
Yes.
Now go over to para 3. So first, my lords, actually para 2, with an order of 21st July 2020, a factual action taken report was sought from a joint committee. So there's a joint committee of District Magistrate and State Pollution Control Board. Accordingly, the State Pollution Control Board filed its report on 27th March 2021 to the effect, and the joint committee had visited, please mark this, on 6th October 2020. Now, with your permission, I'm skipping what they said and I'll take you straight to para 4 on page 102.
Yes.
It's further stated that based on the above, a show cause notice was given for action of closure was recommended. Thereafter, remedial steps were taken as further report of the Joint Committee of Mining Department, which visited the site on 3rd November 2020. Then, my lords, there are various observations. Please just see serial number 6 within the italicized portion. During the inspection, it was also found that no illegal mining was noticed in the forest area of the Aravali plantation. Now I go to para 5. Further inspection was taken on 28th December 2020 by the Joint Committee, and it was found that past violations were required to be remedied, but currently there were no serious violations. Observations and conclusions are quoted below. So then, my lords, I'm skipping now this entire quotation, except you may go to the conclusions on page 104. Italic portion in the conclusions part of that report. It is to be noted that the mining lease for Dadam so-and-so, Govardhan, etc., consent to operate, consent to establish environmental clearance was granted by the state authorities. Simplified mining scheme for working of the mine and geology, Haryana. Inspection of mines was carried out in accordance with the Mines Act. Under the Constitution of India, safety, welfare and health workers employed in the mines, etc. Then Roman 4, inspection was carried out in accordance with the Mines Act. 5, scientific study is not carried out by the Directorate. However, Department of Geology may engage recognized scientific recognition of institutions. It has thus been suggested that at the moment there are no violations. However, following recommendations have been made. And then they make certain 3 recommendations. Please see para 7 of the NGT order. In view of the above, let further action be taken in terms of the above recommendations. We also direct that whenever the mine is closed on expiry of a lease, evaluation of impact of the environment must be conducted before the commencement of a new lease. And if there are violations, compensation must be assessed and recovered from on a polluter pays principle. The Secretary Mining may hold a joint meeting and prepare an appropriate.
When was the second petition filed?
Earlier. So I'll just give that to you. But
which petition was filed earlier?
Sorry, this was first.
This is when was the other petition filed?
Yes, the other petition was filed. I'll just
filed at the same time, pending at the same time itself. Both of them were pending at the same time itself, lordships.
Okay, I'll just give that to you. 20th August 2020.
When was this petition filed?
This petition, as I was prompted by a letter of 8th July 2020.
8th July 2020.
2020.
Was it pending when this order was
Yes,
passed?
both are pending.
Was it pending when this order was passed?
Yes, of course.
No, this is decided in 2021. So it was. That
No, it was pending.
Pending.
Pending. See, if you want to see that letter, which was converted.
Just 1 minute.
9 July, Your Lordship. 9 July 2020 was the first application that was filed. 132. That was my application.
Yeah, yours was first in point of time.
Please, Your Lordship. I moved an application for intervention.
No. So, may I just...
No, we wanted to know which petition was filed earlier.
Yeah, so I'm just giving you, so since your Lordship has that same volume, you will find it at page 20 of volume 5. Just go to page 20, same volume, since we are looking at volume 5. Do you have page 20?
Yes.
To the chairperson, annexure A34, correct?
Yes.
And then he goes to various irregularities, etc., and you will find prayer drawing your attention, 8th July 2020. Rakesh Dalal. Your Lordship has that page.
This is filed on 8th July 2020.
Yeah, on or about 8th July. So it's a letter.
When is the second petition filed?
You said August, no?
This was also in 2020 itself. Around the same time itself, after a few months.
This was taken on 20th of August. First
Yes, that we have.
2020.
The second petition was filed when?
Is the second petition?
The date is not coming, but the first order was passed in that.
Your Lordship will just give me a moment.
Yes.
Mr. Devan, just have a look at now.
Page 24. Just go to page 24.
Yes.
Same volume.
Page 24 is this order in the first petition.
No. Second petition. So you have 169 of 2020.
20th August. Now, Mr. Devan, now go to explanation 6 to order section 11.
I'm sorry?
Go to explanation 6 to section 11 CBC.
Get the CBC.
Yeah.
Thank you. Explanation 6. Where persons litigate bona fide in respect of a public right or of a private right claimed in common for themselves and others, all persons interested in such rights shall, for the purpose of this section, be deemed to claim under the person so litigating. That's correct.
So, and this explanation has been referred to along with explanation 4 in several judgments of this court.
In PIL context.
PIL context.
Yes, that's true.
To say that it will have application, but...
Yeah, on a general analogous principle will apply.
In this case, the petition, if they are already pending, they will not be hit by res judicata, if they are already pending. Because that will lead to a huge issue.
No, res judicata means you cannot... Please see, what's the underlying principle?
That will lead to a huge... And the word bona fide over here is very important because if the report which is given earlier in point of time is not taken into consideration while passing the order in the second matter or in the first matter, then it will have its own consequences.
No, but this is my favor.
We dealt with this issue recently in the state of Telangana matter.
No, I'll examine that, but can I just state the point, my lords? The underlying principle under res judicata is that a party cannot be vexed again and again.
Let's not forget, this is a public interest litigation where the public interest is involved. Otherwise, if we accept this plea, somebody can put up another person, get an order, and that will then order will become res judicata in other cases.
But you're right. So, but this is not such a case. That's why I showed you there were 3 site inspections.
The fact of the matter is, We'll come to this argument now at the last.
No, I agree. I'm not saying no, but Manoj, I'm
We'll
just
come to this argument at the last point.
fair enough. But I'm just saying this is not the way in which
First,
the National
see
Green
the-
Tribunal is supposed to proceed. You appoint a committee. There are 3 site inspection reports. You close the case. I haven't given you the date when they revive this case now.
Just one clarification at this stage.
Yes. But I'll take this point last.
You take your point last.
Yeah.
Because the question of bona fides, etc., will be examined with the last.
No, not bona fide. I'm not questioning bona fides just now. I'm saying as a principle because
Just one thing.
Yeah, sorry.
This order which was passed on 2nd of June 2021, was it brought to the notice of the NGT?
Yes.
It was brought to the notice.
Yes, but that makes it even more, according to me, even more egregious. Once you
take it up in the end.
We'll take it up in the end. All right. So then I'll just complete my dates then, right? I mean, relevant for our purposes. So I have indicated to your lordship that these inspections which took place, your lordship may just note the 3 dates of inspection which are noted in the order. I already referred to your lordship to that order.
Dates of inspection?
Their joint committee conducted an inspection on 6th October 2020, 3rd November 2020, and
October 2020.
3rd November 2020.
3rd November 2020.
And 28th December 2020. Now, these dates.
3 inspections in the second petition?
No, in that first petition. You remember these were the dates which I.
Okay. First.
Right? Now here, just please note that the importance of these dates about 2020 will arise later on when your lordship sees that prior to my commencing operations, which I gave your lordship the date on 25th February 2019, it is found, there's a finding recorded that some illegal mining took place. So one of my answers, which I will explain to you in due course, is that there was no illegal mining and it was certainly not by me. It's a vast area of over 40 hectares, etc. But the important point for these inspection dates is that these inspection dates are, on these dates, inspections are carried out much later after 2019 February, and they found some errors, etc. Curative remedial steps were taken, and the final conclusion was that, look, there are no pending illegalities, etc. And therefore, the NGT closed the case saying that, look, when a mining lease gets over after 10 years, before a fresh tender auction, etc. is given, you must ensure general directions that the party has carried out appropriate remedial steps. That your lordship saw the final operative portion. Now I go to the second present case. So the present case your lordship will see is under the title of Kuldeep Singh. So this was filed on or about, I don't have the exact date, I'm sorry, 20th August 2020. But what's important is that's during the pendency of that first case.
What's the number of the case?
Thus, the new case is 169 of 2020.
And the number of the first case?
The earlier case was numbered 132 of 2020.
Okay. Yes.
Now here, please see an order which came to be passed by this court, the NGT at page 184 of volume 5. Oh, I'm sorry. Yes, it's my mistake. It's volume 1. Volume 1. This is really to also answer your lordship's question as to did they note the earlier order. So we'll put this point last, but just so that your lordship has page 184, your lordships have.
Yes, please.
So now this is 20th July 2021, correct?
Members of the bench were different or same?
I haven't checked that. I'll just let you know. But I'll just place this. So June 2021, as we mentioned to you, that earlier case is closed. I understand the members are probably the same. 2nd June 2021 is the final order. Now see what happens on 20th July 2021. Again, see para 1. Grievance in this application is against illegal mining of a forest area by Messrs. Govardhan Mines. It's the same mine, etc., etc. Now please go to paragraph 5.
Yes.
Learned Counsel for the applicant submitted that the order of the tribunal on 2nd June 2021 may not be treated as final, as the tribunal did not have the benefit of the assistance from the side of the applicant, and thus patent illegalities which exist in mining by the
applicant did not appear in that matter?
Sorry?
There was no applicant appearing in that matter? In the first matter, Rajesh?
I don't know, there was a letter that
There was the letter was there, but he did not appear.
I don't know. Did they appear? No, the other side. But no applicant. It's not very clear to me, Manoj, whether the applicant appeared.
Okay.
So then please see, Manoj, then they quote. I'll just read on page 186.
Yeah.
Please see the submission. Third line on page 186. Conclusion in the report is patently perverse and against the record. It's pointed out that the inspection report submitted on 6th October 2020 by a 6-member committee headed by the Additional Deputy Commissioner Bhivani, including the mining officer Bhivani, assistant geologist, etc., could not be deviated from without any factual basis. The report clearly finds that the project proponent responsible for the violations. The project proponent is the successor of the earlier mining lessee and responsible for the continuing violations that are serious in nature. Subsequent reports by the Mining and Forest Department cannot be held to be reliable in view of the earlier reports. The reports are similar but separate from the 2 OAs filed before the tribunal. The tribunal passed 2 separate orders in the OA seeking reports. In OA 132 of 2000, the report is reproduced below. So now this is in the earlier case. So the whole report is reproduced. Your Lordship will see over several pages. There's a reference to the show cause notice, etc., which was also issued. The conclusions are reproduced all the way up to page 193. Then pick it up at 194 top, please. This is the earlier round, correct? Then, so all I'm saying is, anyway, I'll argue this last, but this clear application of mind. This is not some collusive action. The committee has been appointed. Now, para 10, after referring to the above, it is pointed out on behalf of the applicant that the conclusion in the report that no illegal mining has been done by the project proponent is perverse for the following reasons. So then there are certain submissions which are recorded. And then para 11, we have considered the objections of the applicant and find the same require consideration after due opportunity to the project proponent and after obtaining a further credible report. Accordingly, while issuing notice to the project proponent, Messrs. Govardhan Mines, Hisar, we direct further inspection now by an 8-member joint committee to be headed by so-and-so, former judge so-and-so, former chief secretary, etc., etc. Those details are given. The CPCB and the state PCB will act as a nodal agency for coordination and compliance. The first meeting of the committee may be convened within 2 weeks. The committee may peruse the record, undertake a visit to the site by such of the members as may be decided by the chairman and conduct the proceedings online. The committee may interact with stakeholders and take assistance from individuals and institutions. The committee may also study the satellite imagery maps in coordination with the concerned authorities. The report of the committee may be furnished within 2 months by email, and then the details, etc., are given. The Chief Secretary Haryana may give an action taken report.
In this
Now,
appeal,
this
have
is-
you
sorry?
in this appeal, have you challenged the order dated 30th of July 2021 by specific prayer?
20th July.
This is the order of
20th July.
Yes.
No, this is not challenged. This is not challenged. This then results in the present impugned orders, correct? So this happened, and then I might just mention 2 more dates, and then I'll go straight away to the impugned order. So the other dates which I want, so this is after the final order which your lordships have noted. Now there is a request which we make on 31st March 2022, which I believe is at page 166 of volume 5.
Now, pursuant to this order, some reports would have been filed.
Yes, I'll take you to those. Pursuant to the order of the NGT, you're absolutely right. Now, this is our request for the full report. Your Lordships have page 166 of volume 5.
Yes.
Now, the only reason I would like your Lordship to note this is that this is a report by the HARSAC, which is the Haryana Remote Sensing Agency. We asked for full copies of the report, and full copies have not been furnished to us. Now, surely, if you're referring to a report, whatever it might be, you have to refer to the, you have to supply a full copy to the parties so that we can effectively respond. This has not been furnished to us. And at page 168, we had also at one point of time.
What was furnished to you?
There were some limited pages which were furnished to us. Page 166, at the bottom you will find some reference to that.
Next page also.
Sorry?
Next page.
Yes, next page.
Oh, but this is satellite imagery.
Yes, but it's relied on.
But what was lacking in that satellite imagery?
So the full report was not given to us. No?
This is satellite imagery or some more report?
No, that's the report of the agency. I will, whichever pages I have, I will place before you, because the agency you can't, this is some very minuscule area and the pixels. Just stand up.
Understood your argument. That the full copy, 228 pages out of 465 were given to you.
Yeah, so then we had asked for an adjournment, etc. also.
Okay.
Right. Now, your Lordship's question was, what about the reports which were referred to, etc.? So I'll come to this. So now, my Lords, let us please go straight away.
So how many reports were taken? One is this, obviously, this report you're referring to at page 166. That is HARSAC report.
Yes, now I have a report. I will try and show on the basis of whatever pages were furnished to me that that's a completely unreliable measure. That's one part of my argument. I have placed before you my remote sensing agency report, who confirms, etc., what HSA, RC, etc. has said, which is that given the resolution of the satellite imagery and given the very small area where they say that there is some illegal mining which is taking place, I'll give you that area, the pixels are so small and it is so diffuse that you cannot come to a conclusion and say that somebody is mining excessively, etc. I've of course said that there was no illegal mining, but I'm going to show you that you can't rely on the satellite imagery in respect of a period prior to my commencing operations and before my consent to establish. And none of this is considered. What I'm going to next show you is, I'm going to show you now the first impugned order. Second impugned order is only a review order dismissed. The first impugned order sets out the reports which your Lordship wanted to see, sets out my detailed response, then doesn't deal with my detailed response at all, and just comes to some conclusion and applies that now rightly deprecated by this court stand that we are going to, some 10% of your turnover, etc., you have to start paying. I'll come to that. So on every aspect, your Lordships have already issued orders against the NGT in other cases saying that this adjudicatory function has to be done by you. You can't just keep appointing committee after committee and say that committee says this, so therefore I accept it. There's no substance in your submission. End of the case. That has been deprecated. Second, obviously, natural justice has to be followed in some meaningful manner. Number three, in our respectful, that's regarding that report. Number three, there has to be a consideration of my defense. So now let's see as to how that goes, how we go about it. So now please go to the impugned order. I'll just explain the structure of the impugned order and then come to my points. Your Lordships have, would you please go to page 3. On top, reports of 2 committees, response of the project proponent and the Chief Secretary Haryana. Accordingly, the 2 committees have filed their respective reports in the matter. Report is dated so-and-so. The project proponent has filed its response to the said report on 14th May 2022. The report of the second committee is dated 1st April 2022, to which a response of the project proponent is 19 July 2022. Chief Secretary Haryana has filed a report dated 20th August 2022. Then it talks about, then it frames questions for consideration. Questions for consideration are whether established whether remedy, sorry. Millards, may I request you to go to the foot of page 3, please? After it sets out questions for consideration,
Yes.
whether the violations are established and what are the remedial actions called for. Before we deal with the said issue, we set out the reports and the stand of the project proponent and the state. So this is the portion now I'm going to rely on some portions of it. So he first talks about the report in the first matter of the 8-member committee dated 25th March 2022. Now please go directly. Well, I'm going to focus essentially on only those parts for which there is some reasoning later on in the impugned judgment. So please go to the foot of page 10. Well, your lordships have noticed that from page 4 they are extracting, correct? It's a quotation. Now just go to the foot of page 10, last paragraph. In view of the above, the joint committee has observed that Messrs. Govardhan Mines and Minerals has taken...
That's a fine conclusion. I wanted to see what are the portions where they talk about the violations or the illegal activity.
Yeah, so that's what I'm pointing out here, Manoj. Paragraph 10, page 10, last para. We'll have to go item by item, Manoj. Just see.
Yes.
Last para. On page 10, I'm relying on this. In view of the above, the Joint Committee has observed that Messrs. Govardhan Mines and Minerals has taken steps to suppress dust emissions generated during the drilling and other mining operations, and the Haryana Pollution Control Board Regional Office Bhiwani may continue to inspect the Dadam mining area on quarterly basis and ensure that proper and effective steps are taken to suppress dust generated during the mining operations and other activities of mining. All right. So this is now a primary concern of the NGT, which is pollution. Dust pollution, air pollution. So at least the inspection report is concerned, it is satisfactory. Now go to the top of page 11.
Yes.
The report annexures analyzes satellite data provided by HARSAC, Hisar, vide its letter of 17th March 2022, which has the following table. Your Lordship has that? Now I am skipping Sundar, because that was, you will see the dates are given 17 June 2015 to 30/11/2017. So that I indicated to you, that's predecessor, earlier, prior to me. But I am now Govardhan Mines and Minerals. So please see, image date is 16 February 2020. Then the cumulative area is given. Now just see the increase in area. Now this is very, very important. 0.097. Square meters is 972 and total increased areas given as some 6.33. Now what I am trying to mention is, and what my expert has said is, that from up there in a satellite, given the resolution, to pick on 972 square meters as excess and to try and thereafter hang me and say that you've engaged in illegal mining is completely improper. It's not even scientifically tenable, because we'll get into all those pixels, etc. And when we see the HARSAC report, they themselves in the report issue a caution. But look at the fragment, Manoj. Area in hectares, it's 0.097 hectares on a satellite image. I can understand if there is some site inspection which takes place and somebody finds that I am beyond my boundaries conducting. That's one meaningful way by which someone can say, look, you have exceeded your boundary. How are you doing this? Please correct yourself. None of that. This is on the basis of one image which your lordships have seen on 16 February 2020. 0.097 corresponding to 972 square meters. And nothing out of those 44 hectares which I have. And on that basis, you suddenly pick it up. Now, please go. Then the court, so this, I've made my point here. Now, please see, report dated 1st April 2022 in the second matter by the Joint Committee. Now, here, please go overleaf to page 12. Now, this 1.1 para
10 will also be important. Para 10 will be important because there were 4 deaths that took place. In fact, that's the third committee report, in fact, which has not been mentioned all throughout. Para number 10.
Okay, I'll read it.
After the tableau column, in fact, okay, the report says about 4 deaths that have taken place.
So can I just place para 10? The second report is to the effect that there were violations of safety norms in the course of mining which resulted in the accident in question, causing a death of 4 persons and damage to the environment, compensation stood paid to the heirs of the deceased, but accountability was required to be fixed for illegal mining in violation of norms equal to the value of the mined material and for damage of environment in the light of the cost of restoration. Extracts of the said report are as follows. So, Milos, now there is a quoted portion. I am relying on 1.1 on page 12. May I just place that? 1.1 on page 12 is under the heading, the salient features of the report of the DFO Bhiwani. The landslide is not due to, your Lordship has that? Very, very important. The landslide is not due to blasting. Prima facie, it seems a natural accident. There is no violation in forest area. 2. As far as forest area is concerned, pillar number 31 has fallen from the edge boundary of the mining lease area in the Aravali plantation area. 3. There is no empirical formula to ascertain the environmental damage due to non-creation of green belt. Hence, the office cannot provide any data. No illegal mining has been done at the site of accident in the forest land. And 5. A very small portion of the Aravali plantation area bearing pillar number 31 has fallen in the form of rock boulders of approximately so-and-so and as given in an accident plan map submitted by the project proponent to the committee on 4th February 2022. So this was one of the triggers. But on an inspection and an examination, they were satisfied that this was due to natural reasons and nothing to do with the mining operations. So there's a full and complete clean chit which is given in this regard. Now, please go.
This report is by DFO. Next, my lord, the report is by DGMS, which is expert in the...
No, my learned friend will wait his turn now. I'm just focusing, and my endeavor is to show that there's a complete non-application of mind by the NGT to all my considerations, etc. Now, please see, please go to page 16. You will find objections of the project proponent. The project proponent has filed its response to both the reports. I'm reading para 11. Is that there is no illegal or unscientific mining. Due permission of the Forest Department has been received on 25th October 2019, considering that the approach road in the forest was necessary for entry in the mining area. Bench height was justified. Illegal mining beyond the mining area was done before start of mining operations by the project proponent. The satellite imagery relied upon is not accurate. The project proponent has also denied violation of the depth limit relying on the survey report of a private party. Precise response to the 2 reports is set out below. Now, I'm just drawing it. I'm not going to read the whole of it. But just see how detailed my response is. It's not some generally, I deny this, I deny that. I'm not going to read the whole of it, but I'm going to read certain relevant portions to show as to how in minute detail I have contradicted wherever necessary. Some parts of the report are in my favor. And I have given my material, and you will find eventually there is no consideration by the NGT. Now go to the foot of page 18. This is all part of my response. Go to the foot of page 18. Now please see under 5.4. The heading is illegal mining in forest area, non-mineral area in 0.8 hectares of in Dadam mining hills in village so-and-so. The consolidated reply submitted to the committee is reproduced as under. Now see the last 4 lines on page 18. Further, KML file has been sought in the meeting dated 4th of September 2021 at Haryana Pollution Control Board. Again, the matter has been discussed in the meeting on 11th February 2022, and we were asked to submit the imagery data from 2016 to 2019, specifically on 22nd May 2016, 9th January 2019, and 8th February 2019, wherein it is clearly evident that the illegal mine of 0.8 hectares was already done before the start of mining operations by Messrs. Govardhan Mines and Minerals. Now, please note this, Minerals. We were asked to supply 3 dates before my consent to operate, which is 25th February. I cooperated. We gave these images of 9th January 2019, 8th February 2019. And what those images showed was that 0.8 hectares was already done before the start of mining operations by me.
So I give all these details. Now please see the paragraph after 2 paragraphs, presuming. Presuming that HARSAC might have submitted their report, we requested the committee to provide a report submitted by HARSAC and allow us to present our defense in the matter if in case there has been any discrepancies at our end before the release of the final report to the NGT New Delhi. Request letter dated 21st March 2022 is enclosed, but we haven't received any positive response or opportunity to address our concerns. Final report has been released. After reading the final report, we have observed that the complete copy of the HARSAC report is not given in the final report. We requested the same via email of 31st March 2022, but till date we haven't received the complete copy of the HARSAC report. Further, in view of the final report, we would like to submit that as per the report of HARSAC, it is observed. Now please note this, that 0.097 hectares of mining area increased within and outside the boundary of 0.8 hectare area. The said report is established by analyzing the imagery of 16 February 2020, whereas the previous data analyzed was 8 February 2019, stating the fact that incremental area is observed is between 8 February 19 to 16 February 2020. It needs to be considered here that we have started mining operations from 25th February 2019 and last data analyzed on 8th February 2019 having a difference of 17 days. So here is a sign of interrogation that how the committee have established the fact that this increment in area is being done from 25th February 19 to 16th February 2020, not between 8th February 19 to 25th February 2019. Because we don't have these images, nobody has these images. As there has been illegal mining in period where no lessee existed, so this fact needs to be considered before drawing any decisive conclusion. It's also specifically submitted that according to our knowledge and understanding, accuracy of the data of the satellite imagery is considered as plus minus 3 pixels, where the pixel relates to a resolution of the satellite drone image. It may translate into 1.5 meters if resolution is 0.5 meters and 0.3 meters linear meter if the resolution is 0.10 meter, and likewise. This will have a huge bearing on the area calculations on the basis of photo analysis. We have already requested the committee to consider this fact on 27th March 2022. Copy of email is enclosed. If the accuracy constraint of satellite imagery is acknowledged, then the area alleged over GMM, that is 0.097 hectares, can be concluded and considered negligible. I've raised all these points in great detail. You'll find no consideration. Now just see the last, para on page 19. Shri Rakesh Dalal, who is the complainant in original application so-and-so of NGT, have also filed a writ petition before the Punjab and Haryana High Court. It has been stated that the mining has gone beyond 100 meters. This was on the basis of a survey report got conducted by one Shivam Engineers, and then there's a reference, etc., to the report which has been made. Enclosed annexure. In the said survey report, it was reported by the surveyor that the mine depth is more than 100 meters, etc., etc. Further, it is required to mention that after the survey, previous leaseholder has been permitted by the Honorable Supreme Court on 30th November 2017. During his period of 3 months, extensive mining has been done, etc. Now, this was an order by a bench presided over by Justice Lokur, who had allowed that previous gentleman to continue. And so we are pointing out that, look, that was done by him. But anyway, now, my lords, please skip the next few pages and go directly to page 23, just the heading. Now, you will see these are all detailed responses. Then response of, you will see the heading, response of the project proponent to the second report. You're also by the top of page 23. Again, very, very detailed response. Now, please go overleaf to item 4 on page 24. Unit, now this is the complaint or the grievance. Unit has not maintained the 33% green area out of the total lease area of 48.97 hectares in the lease area. The total plantation to be done in 5-year plan period is 16.1. Let's 5-year plan. I'll just state the point. This is 2019, 2020, 2021. They are in court. We have pointed out that trees take time to grow. total plantation is to be done in 5-year plan period of 16.127 hectares, out of which 9.2018 hectares plantation is done till date, having 21,258 plants. Total plantation is required to be carried out in statutory barrier in about 3.91 hectares, out of which 1.78 hectares is developed as green, and remaining 2.13 hectares in statutory barrier and 4.7983 hectares outside the lease area shall be developed in the remaining 2 years as per the mining plan. And then we have given the revised phase-wise proposal. Thus, we have not violated any mandate of the mining plan, so we should not be alleged for the matter of violation. Plantation record is enclosed herewith. Further, as already submitted, that before starting mining by us, Sundar Marketing has carried out mining and there was no green belt or barrier of 7.5 meters. Yet we have started the same, and that we assure that within the time the green belt shall be fully developed. Now, please go to the foot of page 26. Roman 4, towards the bottom.
Yes.
Now I'm on green belt. Roman 4. Project proponent has carried out plantation in 1.78 hectares against the total plantation to be done of 7.5 meter barrier. Total plantation to be done in the 5-year plan is 16.127 hectares, out of which 9.201 hectares is done, having planted 21,258 plants. Total plantation is required to be carried out in a statutory barrier of so and so.
Let's see the finding conclusion.
Yes, now, so this is now set out, and then we have put in our replies and recommended. Now see his.
Page 30.
Yes, please go to page 30, 30.
Yes.
Yes, please go to 30. Consideration today, findings and directions.
Yes.
It is patent from the reports, the fact-finding committees, that the PP has undertaken mining illegally beyond the mining area and in violation of the mining plan as confirmed by satellite imagery. Now, I just want to pause here for a moment. I mean, this is a line you can put into each and every order. The PP has failed to provide necessary green belt of 7.5 meter width along the lease boundary in the lease area and to provide safety zone inside the lease bound area. Let me read the whole of it, Manoj. Compensation thus has to be assessed and recovered from the project proponent for undertaking mining beyond the permissible mining area and beyond permissible depth, and also the cost of restoration of damage to the plantation apart from cost of illegally mined material. It is well acknowledged that unregulated mining activities result in serious damage to air, water and land. The same involves blasting, drilling, cutting, blowing natural hills. Mining operations in the present case have resulted in generations of tons of dust emissions without requisite mitigation measures. This calls for remedial action for future and fixing accountability for past. Now, I want to pause here for a moment. I ask myself 3-4 basic questions. First, with regard to dust pollution, which is as general, blasting, mining causes this, that. There's a specific finding in my favor that dust, all those measures have taken place. And if in the future there has to be obviously monitoring, I can't be doing mining operations without all the abatement measures, which I'm required to do. But there is no such finding at all. And still some general observation is made affecting natural environment, blowing natural hills, etc. So completely unjustified. Now see the point regarding satellite imagery. No discussion of the fact that the full report is not given. No discussion of the fact that this is such a minuscule area. No discussion of the fact that these pixels can't work.
Did you in any way specifically raise the argument during the course of arguments?
Sorry, of course, he's reproduced it. Sorry,
that was earlier in point of time. At the time.
No, this is, I'm reading the impugned order of the portion I read. Please go back, just go back straight away to page 19. He reproduces it. Page 19, just go. Just go to 10 lines from the top on page 19.
Yes.
Final report has been released on full report is not given. Complete copy not given.
So where did you raise that argument in the written submissions that you are not?
This is my written submission. Page 19. He's reproduced it. Please see. Okay, I'll go a little slowly. Just, may I take you to page 19?
Yes.
Yes. Now, Manoj, I am on the right-hand column on page 19.
Yes.
And I'm just reading it because this is where we are concerned with that HARSAC report. Correct?
You have said complete copy of HARC report has, final report will like.
Not given in the final, and I've gone in detail, I've explained how the whole thing is not done. I have made a whole detailed argument. No, not only not given the full report. Apart from that, I have merits arguments in my thing. That
Okay,
how
next.
can you go on this small little pixel?
Next.
No, now just see. So I am now going back to page 30.
Yes.
I am just making my comments. So he doesn't consider, I mean, he as in the tribunal doesn't consider anything of my response at all. I have a detailed response that, look, I have time for the green belt to come up. It's a 5-year plan. There are 21,000 plants which are already planted. We have to do it over a period of time. None of that considered at all. Satellite imagery, I raised 3-4 points, apart from the fact that the full report is not given. I mentioned that these pixels are too small. Your Lordship saw that. I read that portion. Where is the discussion and consideration of that? I have said even otherwise it goes down to some fraction, 0 point some 0. What was that area which I gave? I indicated to the
0.097.
Sorry?
0.097.
Yes.
That
0.097 hectares. That's some absolutely, Milord, you can't do it on some satellite imagery without any direct evidence. But there's no consideration. At this point, I'm pointing out there's absolutely. So I would respectfully submit my final comments on para 14 are, number one, as far as satellite imagery, this one line which says satellite imagery without considering any of my responses is most insufficient. The area itself was, the report was not given, and this kind of one satellite image on a pixel can't be utilized to hang me in this manner. Second, I have indicated with regard to the green zone and the green belt, I have made my submissions. The third is these general observations on air pollution and blasting, etc., are completely unjustified when the finding is in my favor. So how could you read? Now please see para 15. Only point emphasized on behalf of the project proponent during the hearing of the committee has found that the percentage of illegal mining attributable to the project proponent, 6.33%, first needs to be further reduced as the project proponent commenced mining only on 25th February 2019, while the last date of the image considered is 8th February 2019. For the period from 8th February 19 to 24th February 19, mining was done by somebody else and not the project proponent. We do not find any merit in the submission. There is no material to rebut the last image of 8th February 19. Liability of the project proponent has to be taken only from 25th February 19. However, we note that even on 8th February 2019, the project proponent was in possession of the mine and there could be no scope for mining by anybody else. This was over 40 hectares, which I told your Lordship. And it's my specific case that I was not carrying out any operations until I got my consent to operate on 25th February. Video order of 4th December 2018, the High Court allowed the project proponent to commence mining. But that I had to go there to the High Court, but I couldn't commence because I had no consent to establish. I had no consent to, I had no lease on that day.
Devan, that will not cut eyes. That will not be the issue because even if you did not have consent to operate, if you are operating, that will be violation.
But there has to be some evidence.
That evidence is primarily based upon the satellite imagery.
What satellite? I am going to show you that satellite image. It's a joke, my lords.
Then no, let's put.
How? What satellite image? Some one pixel over here on one area.
That is something different. We are not. Then you're challenging the satellite imagery itself. That's something. That's a different argument. The first argument is once you're given possession, once you have been given that LOI. Nobody will allow anybody to do illegal mining once you're given that.
There were no mining operations at all.
The very fact that you say, I was given the LOI, I had the position, but somebody else was doing.
No, I am not saying that. Well, I am not saying that at all. I am saying there has to be some hard evidence.
You are right to that extent.
Some cogent evidence.
Nobody will allow anybody else to illegally mine the area which has been allotted to you.
No, I agree with your Lordship, but just
it's going to lead to a lot of, if you accept it, it may be very difficult.
No, I agree, but the total area is 972 square meters.
On the other aspect, that the satellite imagery is not fully reliable because the megapixels may not be so accurately be able to point out That's something which has to be
Yeah,
done.
but it has to be at least considered by these gentlemen. Anyway, but it's 972 square meters, my lord, out of 44 hectares. Anyway, let me just read on. Para 60. We do not find any merit in this. There is no material to rebut the image of 8 February 19. Liability of the project proponent has to be taken only from 25th February 2019, etc. Then, my lord, he refers to the High Court judgment. Then, reading on. The project proponent filed an application for consent to establish on 21st January 2019, which was allowed on 10th February 19. Thus, it is not possible to accept that from 8th February 2019 to 24th February 2019, someone was in control of the mine in question. Learned counsel for the project proponent fairly stated that in case the plea for the mining area was done prior to 25th February 2019 by an unknown person is not accepted, quantum of penalty towards illegal mining has to be upheld. In this view of the matter, penalty for illegal mining equal to the cost of mine material already assessed has to be treated as final. We thus uphold the report with the observation that the date of the project proponent came in possession and was permitting.
What was the report? What was the report given by the authorities with regard to illegal mining? That's been. Did you challenge that?
No, we've challenged everything, but
no. This is swarm.
No. Oh, sorry. I understand. So now, my lord, so that's another ground which I'm just thinking. So your lordship's question is that so let's talk in illegal mining maybe for 10 reasons. It maybe you were doing it outside the area, you were doing it before your lease, etc., etc. For that, there is a separate set of proceedings which are going on before the relevant authorities, and a penalty has been imposed on me, which I am challenging. So I was in an initial round successful in getting it set aside. It was remanded back. Then remarkably, on the remand, they increased the penalty imposition. So that is being challenged in a separate thing. But that's not the environment. That's your lordship is right to put that question to me with regard to the penalty proceedings under the Mines and Minerals Act. So that is a separate channel. Here I am fighting, sorry.
There are proceedings pending under the...
Yes, those are pending. I mean, there's a challenge, etc., which is pending. That is going to be my submission. So,
is it correct? If I remember correctly, we had remanded the matter in the other... There was a remand order passed in that case?
So I
just... Can I party to that order?
Sorry, can I just...
Party to that order?
No, it didn't come up here. I don't think it came up here.
If I remember
no,
correctly...
Is
there some other matter where remand order was passed?
Has Justice PNA heard it? Has he heard it?
I'm a party to that order. Page? 13.
It's item 13.1, your lordship.
Okay, that's item 13.1. Okay. Okay. Let's continue.
Yes, sorry. I wasn't aware of that. But there's a re-evaluation of that, no? I continue?
Yes.
Yes. Now, let's please see the foot of page 31, which is where I was. With regard to the cost of damage to the environment, the PP has disputed liability of 7.5 crores. According to it, there is no basis for the observations
that this amount was equal to 25% of the profit as of the PP as per the balance sheet supplied by the project proponent. Further, figure of rupees 310 crores as turnover is also disputed. It is submitted that the levy of compensation has also to be on its predecessor for damage to the environment. While we hold that the project proponent, sorry. Yeah. Be ready,
That's one thing. Look, this orders doesn't appear to be dealing with the contentions raised in absolute terms.
Lord, in fact, as your lordship
I don't want to use any other word.
As your lordship has seen para 15, my lord, during
No,
the course
it's
of
not.
arguments, my lord.
No. That's not the way. Look, we are there. It does appear this argument to the effect that I don't know what happened. Somebody else may have done it. Cuts no ice. That doesn't cut ice. But then arguments have to be dealt with. After all, you are the first court. You are the first court of the first instance. The court of the first instance, the role is very different from that of an appellate court.
So far as that,
and in case where substantial question of law can be only raised before us.
So far as that issue is concerned, that he could not have done mining because without clearance. In fact, the fact which he has not disclosed before this court is that he approached the High Court that my application for clearances are pending and till the time they are cleared. Since the EC is already there, I should be allowed to commence mining.
That factum should be mentioned in the. That factum should be mentioned. Then in the order, reasoning should reflect that.
They are kindly see. They have mentioned the order about
very often. Very often, let me put it.
It is there.
Very often, most of the. If you look at this order,
Para 16, if lordship may kindly come to again. Para 16. I have annexed that order in my counter of the High Court, 4th of December.
One minute, please. Don't interrupt like that. The issue is all the contentions raised by a party must be dealt with. You are right. When most of the judgments we write also, most of the time deal with the facts and then the contentions of the party. Reasoning is relegated to the last part. In fact, the reasoning should be the court. But the reasoning over here starts at page 30 and 31. 3 paragraphs is the end of it. And then the quantification apart is there.
But in fact, in para 15, they have noted that during course of argument, this is the only point raised by them.
No, that's also not correct. Then why quote that all those objections?
Those are the response to, those are not written submissions.
No, those have to be dealt with.
You would see,
we'll continue after lunch, but probably this requires
a response to the report, not the written submissions. Kindly see what has been reported.
No, please, that's not the way to deal.
That is the heading, my lord.
You can't look. We are with you. We specifically said we are not impressed with the argument. I didn't know what was happening when I had LOI. That is not acceptable. That's a lame excuse.
Please, my lord.
And if he doesn't know, then he should not take that lease. And he's saying that India is more, I don't know. Obviously, if you're going to pay so much money, then you'll also be responsible to ensure that nobody does illegal mining. Nobody will permit that. And after all, once the lease is given to you, LOI is given to you, you can't say if we start accepting that argument, it will be a disaster.
Order has been concealed by him.
But the fact of the matter is, you have to deal with other arguments raised by him.
That is not there. In fact, the order says during course of argument.
What we like to know is after lunch, first go to 13.1. What does it say? We'll straight go to 13.1.
Yes, ma'am.
Because that may be having that data with regard to more details maybe there. We just go to 13.1 because 13 doesn't really, the reasoning is not up to the what's required from a first court. The reasoning and consideration, the conclusions, how they have to be drawn. Reasoning and grounds for reaching conclusion are far important. You have to deal with each contention.
Item number 1, my lord, the council has been designated as senior counsel by the Delhi High Court, my lord. Mr. Santosh Kumar Tripathi, my lord. Kindly permit us to file the fresh wakalat number today. Whatever the order
is.
Sorry, my lord.
We have disposed of that matter.
Yes, my lord, it has
So then please keep it, please keep your calm.
My lord, may kindly
All right.
permit me to appear.
All right.
My lord, may kindly permit me to submit the appearance physically, lordship. I could not.
Which one? Which
Item
one?
two, item two, lordship.
Item?
Item number 2.
No, we normally take electronic file.
Because
How many advocates are you? Okay, take.
Thank you.
Please, my lord.
Would you like to?
Just 1 minute.
Yes, sir.
Fill them out on that.
No problem.
13.2.
Lord, the first and foremost argument of the petitioner is about the possession of the mine, that they did not have the possession and that could.
We are not going into any
Yes.
of these things, except one thing we'll clarify. The principles of res judicata and constructive res judicata here will not apply. That
Please,
will not allow them.
Please,
to
my
do
lord.
this.
Grateful, my lord.
And that was decided by the first order. They have not even challenged that order.
Grateful, my
So
lord.
they can't raise that plea.
Grateful, my lord.
If it had to be, it had to be raised.
Why can I not raise it?
No, no.
I'll give you a judgment, recent judgment of our court, which follows a long line.
Mr. Diwan, on this case, in this case, the simultaneous proceedings were going on. We will not permit that. Be very clear on that. Go on the merits. If you have something on the merits, fine. If you don't have something on the merits, then you then be issued.
All right.
That we will not. And as far as other issues are concerned, we'll pass an order or remit without making any observation.
All right, very well. Issues and contentions except res judicata kept open. And that full report to be supplied. What? Yeah, it'll cut short the controversy.
To that,
What about the second case?
My lord, the second case is with regard to the penalties, my lord. Now, my lord, what had happened is once the director issued us a show cause notice, he issued us the final penalty amount, my lord. We challenged that penalty amount before the additional chief secretary, my lord. He set aside that order, he remanded to the director and the director reassessed the amount. It was from 29 crores, it came down to 15 crores. Then unilaterally, my lord, the ACS took again a decision, quashing that 15 crore order.
What is the reasoning given? Let's see.
Please, my lord.
What is the
My
reason?
lord, that is, my lord, what has happened is we have challenged
This is the order passed by the
High Court.
High Court.
Yes, my lord. My lord, the issue before the High Court was with regard to the order passed by the ACS, whereby the ACS stated that now the assessment will be done by the ACS himself. The assessment has to be done by the director.
I didn't understand your argument.
My lord, the penalty has to
Who had imposed the penalty initially?
Director.
We have not read the file, so
Yes.
please be careful.
Yes, it is by the director. My lord, the rule says it is by the director. Rule 2074 says.
Director of whose director?
Director Mines.
Mines and Geology, my lord, Haryana.
Haryana.
He has to.
So, Director Mines has imposed penalty
Of 29 crores initially.
29 crores.
We challenge that order.
What was the reason? Where is that order?
My lord, that order is
P16, my lord, in the
P16, my lord. The relevant will be, my lord,
What is the
at page number 180, if my lord may have.
Page number?
180, my lord. Now, my lord, in that there is a table, my lord. Now, my lord, with regard to item number 1, 2, and 3 is a separate issue, but on 4 I am stating before my lords. Now, my lord, this is the majority of the amount which is they have assessed to be illegal is 9,80,000, my lord. Now, my lord.
1 minute. What is the reasoning given here?
My lord, they say that the depth of that pit was 78 meters. Now, my lord, one of the petitioners, one of the respondents in the earlier petition, Rakesh Dalal, in 2017-18 before the Honorable High Court, he filed a PIL stating that the earlier Sundar Marketing had brought that pit down to 100 meters. So, my lord, I started mining in 2019, my lord. He in his earlier petition.
We are very clear on that. We don't know.
Yes, yes.
We are not going into that. You may be saying A, others may be saying B.
Yes.
We are not going to that question.
So, my lord, this is now they assess it total at 10,66,000. And then, therefore, on this amount, they said that the total penalty upon you is approximately 29 crores, my lord.
So, this was
challenged by us.
This was, the pit could not have been dug deeper. The pit could not have been dug deeper, or this is the quantification made by them on the basis of a non-declared excavated mining.
Both, my lord.
No, my lord, it was basically the pit when we started mining, my lord. It was
1 minute, please.
Yes.
We just want to know what is the basis on which this penalty has.
Basically, my lord, the report submitted before the NGT of that 8 committee members, my lord. That is the report on the basis of which this assessment has been done, my lord. But that report also is in our favor, wherein the report also says that it is already
primarily based upon the report which was relied upon by the
NGT, my lord. My lord, the only issue
you had gone to
the issue.
1 minute, please. Once that order goes, then this order will not be sustainable.
No, my lord, there's something else, my lord, in this petition, my lord. We challenged this order. It went before the additional chief secretary, my lord. He set aside this order, directed the director to reassess it. He reassessed it. He brought it down from 29 to 15 crores. ACS again passed an order, quashing that order, whereby it was brought to 15 crores, and said that now I will myself decide the penalty amount. So we approached the Honorable High Court that under Rule 75, it has to be assessed by the director. Because director
No, that's not. Appellate authority has the same power as the first authority.
No, because it has to be reassessed.
No, maybe. Let it be. Once they have assessed it, the appellate authority.
Now,
look, please, look at the argument of yours. And the fallacy in that argument is quite apparent. There is a penalty imposed by, say, SEBI of 1 crore. The SAT can reduce and requantify the penalty. Your argument is SAT cannot do it. How can that be acceptable? The appellate court powers are same.
There's one more thing, my lord.
That is wrong. That argument.
Now, my lord, now what has happened is, now after that 15 crore penalty amount was quashed, now, my lord, they have reassessed it. Now the reassessment is solely on one basis.
That will be challenged now in the.
It is pending before the High Court, my lord.
Correct. Let it be remain pending.
Yes.
This point being not detailed.
No, only one submission, my lord. Now, in that order also, the ACS has said nothing. He says only one thing.
Subject matter of challenge, not before, before the High Court.
Only one statement, my lord. He says on the basis of that report, which has been submitted by the 8th.
That you raise before, after you pass this order, you raise that plea before the High Court if you have.
No, my lord, it has relied on only NGT order and said.
I understand that, but that order is not before us.
No, it is. It is in the second petition, it is.
There is a third petition also.
No. The first petition is.
1 minute, please. We understand that, but because this is an order of this, in this case, your challenge before the High Court was limited to the fact that the appellate authority cannot reassess damages.
Please, ma'am.
There you are wrong. Right on. Item 13.
So I'll withdraw this, my lord.
Okay, right. Item 13. We have heard the parties
and all the contention may be kept open, my lord.
And also on various issues which arise for consideration and have been raised, with various issues which have been raised before us and which arise for consideration. So stop. We feel that an order of remand is required to be passed as the entire reasoning of the tribunal is to be only found in paragraphs 14, 15 and 16, which in our opinion do not deal with most of the contentions and issues. So stop. In these circumstances, we set aside the order dated 22nd of August 2022, passed by the National Government with an order of remand proffered. 22nd is
26th of August.
Yes, or 22nd.
26th.
26th August 22.
There it is 22nd. No, that's not. 22nd stroke 26th August 2022 with an order of remand for fresh decision after taking into account all pleas and contentions except the plea of res judicata and constructive res judicata, which in our opinion the appellant should not be permitted to raise in the factual matrix of the present case, and keeping in mind explanation 6 to section 11 of the Code of Civil Procedure 1908.
My lordship may fix a time frame within.
The order dated event 26th of 26th of August. 34 is the order. Consequently, the order dated 18th October 2022, dismissing the application for review will be also treated as set aside.
In the second.
My lordships may fix a time frame within which it can be concluded.
Parties, in order to cut short delay, parties are directed to appear before the National Green Tribunal on 29th of January 2025, when a date of hearing will be fixed. Next, in 13.1, you say, run it down.
All the contention may be left open as
All,
the CS has.
we clarify, we have not expressed our view either way on the pleas and contentions raised by the parties. 13.1, Learned Counsel for the petitioner seeks permission to withdraw the present specially petition in view of subsequent developments and will the liberty to raise all pleas and contentions before appropriate fourth stroke High Court.
Highly grateful.
My lordships may formally allow my application for intervention, your lordship.
No,
my intervening application.
I'm not saying anything.
My lordships, in fact,
Move it there before NGT.
I will do that, your lordship. And my lordships may actually.
You are already a party before the NGT.
I'm already not in the second round of litigation, lordship, not the second petition.
Third.
In fact, everything was initiated at my behest itself, and including the impugned order.
Or before the NGT.
Yes.
And my lordships may not allow them to actually continue because the threshold was 80 meters. Now they've already crossed 109 meters for 10 years.
Is that please before the NGT? We're not going into that. We are concerned with the impugned judgment. That subject matter is not before us.
But otherwise, it should not be construed to permitting them to actually.
We are not saying anything. We are playing all pleas and contentions are left.
Grateful. Now, my lord, there's a consequential direction which I request because pursuant to the
order that 3 crores you want to refund?
Yeah, my lord, ad hoc. Your lordships have mentioned.
Okay.
It's an ad hoc.
Rupees 3 crores deposited by the appellate along with interest accrued, if any, will be refunded to them.
Well, it's some order on my application for implementation. Otherwise, let's say my application is pending before this.
We may not. We one sentence here. Application for implementation has been filed on behalf of
Mr. Rakesh Dayal.
Mr.
The original.
Rakesh Dayal. As we have disposed of the matter. As we have disposed of the matter, we are not deciding the said application.
Grateful.
Please, Lord.
Lordship, in item 43, a similar matter is pending before this court.
Issue notice. And tag with.
Look at the SLST number. It is pending.
16271.
What's the SLP number now?
16271 of 2024.
16271 of 2024. Notice will be served by all modes, including dusting. This issue will have to be sorted out fast, otherwise there will be a huge number of cases.
So grateful, my lords.
Yes,
The arguing counsel is not available, Lordship.
what do you do? Why did you not tell us in the morning?
Deeply apologize, Your Honor.
It is stated that the counsel for the petitioner is indisposed. Let's next week. Jammu Kashmir, that hospital matter.
Pollution control board.
वो दे दो. No, but are they there? Party should be here. I don't want them to be seen. Item 45. Oh, let it be.
Yes.
Because way down. You are there? You ready to argue? You want to pass over?
Mr. Kailash will be in court too. He's just coming.
Okay, fine. Let him come. Okay.
This is the fifth attempt by Assam Rifles. 4 earlier times.
My lords, I am requesting for a passover.
Oh, you start now. Okay, Ms. Kailash Vasudev is there. Call him fast. Call the council fast. Yes, Ms. Kailash Vasudev. What a mess you are in. You don't have any permissions.
No, the permission.
Consent to operate you don't have.
We had applied for them.
Well, but you have been
That's
rejected.
the report says, my lord, we have applied for
You
them.
don't have the consent to operate, you can't run the hospital. You don't want it to close down, but what to do?
No fire in.
No fire NOC, no consent to operate.
No, all those
are all violations on the.
I'm aware of it. They were kept in abeyance all the way through, but in any case, no.
No, basically, you can't operate the hospital without consent to operate.
I'm making a submission to your Lordship's court in view of the.
And your STP also works and stops.
But
Whether you want.
all that has been taken care of, but there's a dispute. May I make a request to this honorable court? Your Lordship may
deposit the full amount of penalty. Deposit the full amount. Deposit full amount. Matter is still pending or disposed of by the.
It's disposed of. They're pending before your Lordship's court.
We remanded back as far as other compliance is concerned. Deposit full amount. 90 lakhs was imposed penalty. How much?
That will be very difficult for us in our finance.
Maybe, but that's the only way.
It will come. No, we are
That's
not.
the only way we can enforce compliance.
No, we are not escaping. We're not even going.
But yet you have because without. Tell me one thing. Can you operate even a single day without consent to operate?
No, I agree there has been a default there, but we have been.
And default not for 1 year, for 4 years.
No, but they permitted us. They never said.
No. There's no question of permission.
I understand.
No, you've been doing it in entire violation.
It's a 500-bedded hospital. It's a medical college.
Deposit that. We are not therefore asking to close it. We are going to ask them to, and your STP must work every day, now.
It's working now.
No, sorry, you had made a bypass also. Forget about it. Bypass must be closed.
Bypass was recommended to us by.
No, and what you are doing otherwise is just pouring in water, fresh water to dilute the content.
No, that report I have disputes about, but in any case, I don't want to get into it. I had a different suggestion. After seeing this report, we want to take advice of another expert because we can only consult one set of experts in J&K. Lordship, grant us permission to take.
We are doing it, but deposit the full amount.
It will be impossible for us. We've deposited 40 lakhs for us.
Yeah, I know we have deposited. How much was the penalty?
1 crore 37 lakhs.
That's 1 lakh.
You deposit 1 crore now. Deposit 1 crore. Total amount.
Make it a round figure.
60 lakhs you deposit for.
Very well. What should we give us 2 months, Manoj? Because we don't have that kind of money just now.
That cannot be permitted. That's not. It's not.
But I'm asking for it because of the students and everybody.
What about fire NOC? You don't even have fire NOC.
No, those are all there. That's the report I want to contest, but I was making a totally different submission.
You deposit.
We'll deposit 60, or we'll deposit 60 more. I have one request from it. Lordship may give us 3 months. Defer this by 3 months.
You deposit.
We will deposit.
3 installment, 20 lakhs.
Very well. Another request to Lordship's court. We were told that we wanted to take advice from outside agencies.
Please do whatever. Who's stopping?
No, Lord. The Jammu and Kashmir authority say we can only consult these particular group of operators. We cannot consult anybody else. Lordship may give us permission to take.
How can you insist that only these people will be consulted? How can you tell the business there should be open to consult anybody? Why should they restrict? Why should you tell them whom to employ or not to employ?
The whole state.
No, sorry. That's not
said so in the strict.
No, please. That is
We'll take assistance from others.
1 minute. Then you take over. You do the work. They'll pay you the money. You make it comply.
Take the assistance of others also.
All that I'm saying is,
That's not regulation. That's control.
We'll take the assistance of others. We have not strictly said like that.
Well, what I'm requesting is we'll deposit this.
That's my prayer.
We are thinking of remanding the matter to ensure that you make compliances. If you don't take compliances within 6 months,
very well, Lord.
You will be out.
Very well.
You'll be locked.
And in the meantime, please give us liberty to consult another set of experts for this.
You may do it, but if you don't have the requisite consents and you do not make it operational within 6 months, fully compliant within 6 months,
yes, Lord.
You will lock it up.
Your Lordship, Gary. Because even in the report of the DP, a lot of compliances have taken place since. It is not that there has been an avoidance.
We want the State Collision Control Board to be also taken to a task. What did you do without consent to operate? You allowed the hospital to run? And what is your report? If you had not asked the Central Pollution Control Board to give their report, it would have been.
We have said so. We have said in
No, you have not said anything.
Lordship.
You cover it up. Shows?
Yes, Mullah.
Shows where you said you have not, do not have consent to approve.
Yes, yes.
They've said so in the,
Yes, Mullah.
they've said so in the previous orders also.
Not in the latest report.
I'll show you.
The previous orders.
Yeah, they expect us to search for whatever wrong you have done.
I'll put that notes.
Yours is the latest report of yours. Where is it?
Page 3. Lordship may have page 3 of my first affidavit.
First report.
That's report. That's filed by this. I'll show you.
This report was filed on 27th August 2024, in which you make no mention of the fact that they had no consent. After seeing this report, we asked the Central Pollution Control Board to carry out an inspection.
I don't know what happened, why we did it, but there was we had there's something wrong.
Lordship, give me just 1 minute, please. I will search.
Write up the appellant, name of the appellant, deposit further amount of rupees 60 lakhs by way of 3 equal installments of rupees 20 lakhs in the period in the month by order before.
What's it, mid-February, Manoj?
30th of January 2025, comma,
mid-February.
28th of February 2025 and 31st of March 2025. Full stop. We have directed the said payments in view of the report submitted by Central Pollution Control Board.
Page 3.
As well as the
pollution
affidavit filed by the appellate hospital accepting that they do not have consent to operate since 2021. Full stop. The amount once deposited will be utilized along with the earlier payment of rupees 40 lakhs will be utilized for environment protection purposes as per law. So suitable directions in this regard will be issued on the next date of hearing. In the meanwhile, we direct the appellate hospital to ensure full compliance within period of full compliance of the rules and regulations under the Air, Water and Environment Protection Act.
And the rules.
And rules, including medical waste rules.
The biomedical waste.
Biomedical waste rules. On or before 30th of June 2025. Stop. In the month of July 2025, Central Pollution Control Board will carry out inspection of the respondent hospital and submit a status report with regard to compliances, etc. They will be permitted to take samples and submit test reports as well. We have some reservation on the conduct of the Jammu Kashmir State Pollution Control Board.
May I make a request? May not mention it. It will prejudice me. Lordship will do this in July. At the moment, let me get past what I'm going to. I appreciate what's falling in this honorable report.
Page 3, we have mentioned it.
Your report leaves much to be desired.
Well, let's pay. Could you
just take it?
Where in page 3? Which paragraph?
Page 3, my lord, of our report. Page 3 of our report.
24 report.
No, man, it's before that.
This is the last report you filed.
No, man, it's before that. Before that, we have filed one.
Anyway, convey our displeasure very clearly.
I'll do that.
Correct? If we require, we'll call them to court and tell them what we want to say.
I'll do that.
We are not passing any detailed order because of, but at the same time, both of you were mixed up.
I'll do that.
this order does not, the aforesaid direction does not bar the State Pollution Control Board or the Central Pollution Control Board or any other authority from carrying out periodical inspections from what we call periodical inspections as per law in the said period. Full stop. Relist in the week commencing 4th of August 2025.
Your Lordship, may just recall that we have been entitled to take advice.
Yes. The applicant also permitted to take expert help from specialists from outside the state, outside the Union Territory of Jammu. Earlier.
We had consented.
No, we had consent.
We had 2011 onwards, we had consent.
You had consent till 2021 or you didn't have consent?
2011, isn't it?
Okay.
We had earlier consent.
No, you did. 2012, you don't have consent.
So 2012 we had, then we applied afresh, but they said this is to be done.
But that was not,
since 2000,
that was not granted. After that, it was not.
Only in 2012 the consent is.
Yes, yes, only thereafter it was not granted. That's what we are saying at
2012.
2012.
Yes.
It was granted till September 2012. After that, no.
Since September 2012.
Not 21, but 2012. I was going to correct it myself. I was going to mention that to your Lordships in the audits.
I'll change that.
Grateful.
With that odd direction we give on the next day, because that amount has to be spent. I don't want to give it to Pollution Control Board or anybody else or the state government. That amount will have to be spent. We'll appoint a committee to spend that amount for. The amount has to be deposited in the court.
Yes. We'll deposit. Lordships given us time till March.
Report.
Yes, the amount once deposited will be converted into an interest-bearing FDR with auto-renewal clause.
Grateful.
This report by the CPCB Malats also mentions that they have not paid the EC Malats environmental compensation of rupees 97,34,800.
Two sums there.
That's also with them.
So what is your some penalty has been reported?
That the water said they have not paid it, my. They have not paid it.
1,37 lakhs is the total amount.
That's a balance amount.
That's a balance amount.
That's a balance amount. We have asked them not to look on the question of quantum of penalty. Again, there's a huge debate. How do you calculate the penalty itself is subject matter of litigation.
We'll leave it to your Lordships.
So I'm not, therefore, I'm not asked them to deposit 1,40,00,000. They've deposited 40. We have asked them to deposit another 60. It's good enough to tell them that we are not going to be lenient with it.
Yes, we'll leave it to your Lordships. Grateful.
Grateful.
Yes, please.
This is my feel, Malans. In short, Malans, what has happened is what the court has done.
We had asked you to tell us how they are different from others.
Malans, Malans have seen the written submissions which and
Let's see,
those
what
three
have you
charts.
said?
That's it. Lordships are.
What's your item number?
14.
It's 14,
114. 3 comparative charts which we've given.
Page number?
Malans, the first chart is Appendix A, Malans. In my number, they have not.
Poor people.
Eligibility criteria.
Thank you, Mr. Banerjee.
Well, it's a written notes of submissions which we've. Has it been filed? Yes. Instructed that it's been filed.
That's fine.
What is this? Let's see. उनकी well, I can find out in minutes. Let's keep it over, Malaz. I'll try to find out if need be. I've been instructed that's been filed. Malaz, I've just indicating, Malaz, there are 3 charts which are enclosed in this in relation to eligibility criteria, in relation to the other cases where benefits have been given, and third is their recruitment rules and how they are affected. I've given 3 charts. But Malaz, the crux
The
of
pay scales are different, or the pay scales are different, or certain perks are not being given.
Well, the issue is this.
One minute, Mr. Banerjee, what is the difference between Assam Police and other paramilitary forces?
I'll answer that question.
And first you tell us what is the pay difference or the perk difference, and then why they are not eligible or they cannot be treated at par with others.
Given that, I'll just summarize it in precisely.
Take the mic in front, or you come on this side.
I'll just summarize it. Assam Rifles and CAPF, other CAPFs, on 2 categories have been given pay parity. One is combatized category, and one is radio mechanic category. These are non-combatized categories, all of them. They have different rules of recruitment, different methods of recruitment, everything. They are like chalk and cheese, apples and oranges, all of them. So according to us, and when it came to them, they were specifically rejected.
That's not argument. That cannot be ground in the court.
I'm just...
You please, that rejection is their cause of action. So that cannot be a ground in the court.
Yes. I'm not saying that's not. I'm just saying this, that it was granted their equivalence. Lordship has seen the...
One minute, who are the respondents? Which category they belong to?
Well, there are various different groups of people, electricians,
they're non-combative. They're non-combative?
Non-combative groups.
Okay, fine.
And that's our thing, that they cannot be bunched together.
But the other central police forces also have non-combative arm.
They have non-combatized. They have non. I can't say that to the wrong.
They can't be there.
Of course they have.
Okay.
But according...
What is denied to them, which the others are getting?
Well, as the others, they would get parity with CAPF. They would get obviously...
I'm asking you what is denied to them, which others are getting. You're not answering that.
The pay scale, obviously pay scale.
What is the difference?
Pay scale.
It's a pay scale difference or perk difference?
Pay scale difference.
The pay scale.
Pay scale difference.
What is the pay scale? Let's see the chart. What is the...
Well, that's the chart which I have given. I don't know whether they have that chart.
Why? इसको इसमें डालूं?
Yes.
Scan.
One chart here, this chart.
Well, so I have it on my digital, Malaz. I can...
No, it's this one you're referring to.
It doesn't look like that, Malaz. There are 3 charts. Annexure, and in mine, it's not even paginated properly. Malaz, I can just circulate my thing. The Lordship will at least know what it looks like. This is what it looks like. And those are my writing, will excuse the bad handwriting. Well, may hold it over for a... Well, I'll just circulate. That's the crux of myself. I wouldn't have submitted anything else. Unless we'll then hold it over, Malaz.
No, we don't want to adjourn it because these are paramilitary forces.
Yes, Malaz. But I'm just saying that...
Stay order operating.
Malaz, I would appreciate, but Malaz will need to just take a look at this for me to make my submit. That's all that I would have submitted. In fact, these charts, I don't think I could have made a case outside these charts. Because according to me, Malaz...
We just put it there. We just upload it on our screen.
Yes. You have a soft copy? I don't know whether I have an internet. Internet on call. But Malas, then have to. Yeah, we're sending it on WhatsApp.
Can you screen share? No.
Malas, I don't have an internet connection. Sanai. But Malas, I'm just flagging. There are two issues which, there are two things which, before we start, Malas, the competized category were given parity. And rifleman, radio mechanic as a category was given parity. That's not what we are.
And that was after a hot water battle before this court?
I'm sorry?
After a battle before this court? Yes or no?
Sir. But Malas, our thing is this, Malas, that we are now, our case is that non-competized category were not, there's no equivalence. It's not even possible to draw an equivalence. That's the long and short of it, please.
May I respond?
Let him argue, please.
Have you sent it? Well, it's been sent. It's gone.
Can you?
We have sent on WhatsApp.
You sent it on WhatsApp? This is now become part.
Yes. Yes. The first chart answers the question. I'm sorry. That is the written submission. Well, the first one is what logic.
No, we have it with us. It's in the second volume.
Yes. Sorry.
No.
That's it. Well, I would only say hiding in plain sight. But it was hiding in plain sight. But Malats will come to the answer which Lordship's answer is at Appendix A, the question which Lordship put me. What would be the Assam Rifles equivalence in CAPFs? What they would be entitled to? Every storekeeper, electrician, every one of those groups separately.
Yes, please.
That's Appendix A of the written submissions. In my PDF, that's page 8.
So the initial entry in Assam Rifle is rifleman.
Storekeeper, Malats, will please come to Appendix A.
Yes, we are at Appendix A.
What is the first? Storekeeper technical, that's where it starts. Technical men.
Yes.
Riflemen, Lordships are right. And on the other CA, minimum 8 years by promotion to head constable, 5 years. Matriculation, basic medic course, advanced map reading standard 2. Matriculation from a recognized board matriculation. No revision RR. Well, this is as per the same recruitment, as per their recruitment rules would also be different. Criteria is different. Electrician.
No, I couldn't understand. Rifleman. And constable.
Constable.
By promotion to head constable.
With minimum 5 years.
That's a further promotion.
Yes.
Here it's minimum of 8 years service. So the stipulations are far worse, far stricter.
Matriculation, promotional cadre.
No, that's not required.
Well, on the other side, the basic medic course is required.
No, please. All constables don't require that. What are you saying?
Well, in this, because it's storekeeper, technical, medical, Malaz.
Okay.
It's not like all constables. Well, these are very specific non-computerized categories.
Okay. This is storekeeper, technical, medical.
Yes.
Okay.
So SAM rifles is lesser, I would say, because it seems to be more specified for CAPFs.
Okay.
Diploma in pharmacy or well, it's advanced medic course or medic refresher course. Electrician, well, it's
Okay, yes. Come to the next. Electrician.
same thing, Manoj. I'm sorry. Electrician, rifleman, constable, matriculation possesses ITI certificate in the grade, and CAPFs, 2 years work period in respective trades, 1 year certificate course or 1 year certificate from Industrial Training Institute or Vocational Institute with at least 1 year experience in the trade, or 2 years diploma from Industrial Training Institute in must qualify trade test.
Okay, there is no revision after 2000. There must be.
No revision. That's per my instructions. I can find that.
There is no revision after 2000.
No, in terms of recruitment rule, there is no. In terms of recruitment rules for SAM rifles, doesn't seem to happen.
No, but they must have been upgraded after the 6th pay commission.
And it's payment, but well, it's recruitment rules wouldn't have been changed. Eligibility criteria has not.
Has there been revision, upward revision after the 6th pay commission?
Or the pay commission of the pay, exactly, Malaz, that I'll find.
Is there a revision on the pay commission? Must be. We're not raised that.
6th or 7th, I'll confirm it.
6 or 7 must have been given.
I'll confirm it. I'll just double check.
2006 and 2000.
Malaz, I have that chart also.
Okay, continue further.
Malaz, I have that chart. Malaz.
So you're basically pointing out that the recruitment qualifications are different.
Absolutely. That's Lordship had asked me that question and I'm answering it step by step. The only one which seems to have some sort of equivalence is armorer, which is over the page. Initial entry, rifleman, constable.
What do you mean by the remark? In your remark column, you say before 2013, number RR is available with this
BSF. Recruitment rules before 2010, no recruitment rules are available with this force. So recruitment rules were not before 2013. No recruitment of ITBP was available with this force. So then they.
So what do you mean by that column? Before 2013, no RR or ITBP?
Recruitment rules, Malaz.
We understand recruitment rules. RR stands for recruitment.
ITBP is available.
What do you mean by this? I couldn't understand.
We don't have records of the rules.
This force means which force?
Before 2010, we don't have records of these rules, and for BSF is available in 2010. I'm sure they would have. But Malaz, broadly,
they will have. The Union of India will not have.
Malaz, broadly, the question is this, Malaz, that there is no equivalence. Malaz, the educational equivalence, eligibility criteria.
1 minute. What you are saying? Before 2013, you don't have the recruitment rules, so you can't comment about it.
Yes.
Whether they were same or different, you can't comment.
Yes.
Correct? Now, as far as electrician is concerned, then again you make the same statement. As far as armory is concerned, it's the same.
Yes, armorer seems to be more or less the same. That's the only one.
That's the same.
That's the eligibility, initial entry, educational qualification seems to be.
Okay, then come to the vehicle mechanic stroke fitter.
Again, 1 year's course from industrial training. There seems to be a larger in CAPFs.
2 years working.
2 years, that's what I'm saying. 2 years in respective trades. So
diploma stroke ITI will be almost equivalent, except it will be virtually the same.
all of this in all of these vehicle mechanic fit
Okay,
categories.
1 minute, please.
Yes.
This is equivalent to 2 years diploma from Industrial Training Institute, which is ITI.
Or 1 year certificate
Leave that.
with at least
Leave that, please. 1 minute.
experience in the
It's
trade.
identical to 2 years diploma
From industry
from Industrial Training Institute, which is
in the
ITI.
trade or similar trade. So this is trade specific.
Okay, fine. That's fine. Come to now.
That is not
One
electrician's
minute.
job.
Please.
Must qualify test, trade test. Must qualify trade test.
They call the trade test, please. It's conducted in the examination itself, induction examination.
There will be an exam.
Or it's afterwards.
According to my understanding, there's an examination, but I'll where are they? Over here.
Come to carpenter.
Electrician, storekeeper, armor, vehicle, carpenter, millets. 8th pass and matriculation, 2 years experience, respective trades, 2 years diploma in trade. So these are trade specific in CAPS naturally, and Assam rifles, millets, it's, I'm not saying anything, but it's the pool is smaller. So maybe the entrance requirements, eligibility criteria would to that extent be a little bit more. And the recruitment rules are obviously different as they would be. Like in nursing assistant, it would be intermediate plus diploma in general nursing program. So there seems to be a clear, I think these are more specified. ये जो trade test होता है,
The same also. Are they not doing the same work?
I'm sorry, man. According to us, they may be, but the eligible lordships, I'm taking coal to Newcastle. Lordships are aware that it's not only about broader doing the same work, but also in relation to the eligibility criteria, the recruitment rules. Recruitment rules are admittedly different at that point of time. And as for qualification, eligibility qualifications. And
tell us which are the other ones where there is a distinction and where there is no distinction.
All of them have distinctions according to us. It's carpenter, nursing assistant. The only one which I see broad equivalence, and I'm saying
Carpenter, what
armorer.
is the distinction?
Is broad armorer. That is 3.
Matriculation, 2 years experience is required.
But the recruitment rules are different. There is no. Well, this is my first argument would be like chalk and cheese, because recruitment rules are completely different from both. So unless we actually make an intervention giving parity in making
nursing assistant is almost the same.
Not at all, Malaj. There is again specific
diploma in general nursing program.
Nursing program.
Yes, what do you say?
Plus, I'll submit.
How do you get out Justice Keher's judgment?
So, I'll submit.
Because Justice Keher does say these are the parameters and don't step into the shoes of the policy making.
No, that's more difficult.
Malaj, there's one more before my learned friend starts. Our basic submission before this court, and I'm saying this again, Malaj, the respondents don't form a homogeneous group to be given this benefit of across the board equivalence parity. That is another point which we have taken consistently, and I'm flagging this because they're all as I said, apples and oranges and chalk and cheese.
No, so firstly, what they are saying, this is the fifth time this argument is being made, because in the fifth round of proceeding. This has happened 4 earlier times. I'll place those orders. I have a chart also. Plus, firstly, are we combatized or not? I'll just explain what the concept of combatized is. Because the combatized concept is in a central armed police force, you will have people who are doing the regular work of the police force, and then you will have cooks, tailors, carpenters, etc. But all of them are also trained in using the rifle and in fighting. So all of us we are technical people, but we are all trained to fight, and therefore we are considered combatized. So on that, the learned ASG is incorrect. He's been wrongly instructed. In fact, it's clear that we are combatized. All of us are combatized. We can fight, we can operate the rifle, we can do anything when need, because the unit moves as a whole. It can't have people within it who are not.
No, you are not combatized, please. Let's not argue. They have drawn a clear distinction. That distinction is there. One are the front force. The front force, you are the back office. That's the difference.
Because that I am not a combatant, but am I combatized? Because they're two distinct terms. And learned ASG has also nothing on the record. They have not ever stated on the record.
Look, these two terms have gained ground on the basis of past practice.
That's correct.
And on the basis of past practice, normally we differentiate between the ones who are the front force and the ones who are providing, aiding and assisting and helping their operations.
I'm grateful to the court.
So that's a difference.
I'm a non-combatant but combatized. That's my respectful submission.
That may be wrong. That may be wrong.
That is it, for the moment.
You must be wanting the distinction to be drawn because there is already a decision of this court as far as combatized force is concerned.
Radio mechanics are also not
1 minute, please. Radio mechanics may not be.
Yes.
But they normally are stationed where the force is stationed.
I'm grateful. Now your lordships will have that distinction. I'm grateful for the question to the court. Kindly have that distinction holds.
1 minute, please.
Yes.
Please tell us what is are the educational qualifications distinct?
Plus, the qualifications may be in minor terms distinct. Minor terms.
Not minor terms, please. That makes a lot of difference.
But your lordships will see what is the notification which we are relying upon, the 97 and 98.
What is the difference in pay scale?
The difference is I am getting 3050 and the entry point in the others is 3200. So that's the beginning point. And obviously it keeps on for every stage, it keeps on going up. So it is most of us have been in service for 33 years as riflemen. We have not had a single promotion.
You get MSCP.
There is no MSCP in this. There is no MSCP in the scheme of the Assam Rifles. So I have nothing.
No, there is no MSCP. Is there no MSCP? How can it be? You must be wrong on that.
I can double check it, but
no, you are wrong on that. Absolutely wrong on that. Please don't make a statement at the bar which is wrong. How can it be?
I'll double check it. But
it cannot be. MSCP will be there. And that is true for promotion in most of the CRPF or the most of the paramilitary.
They were previously applicable.
Today the situation is this. What the High Court has done is this. What fell from the Honorable the Chief Justice when what fell from Honorable the Chief Justice?
We listed in the regular matters in the week commencing 24th of March 2025.
Now, may I just make one request, Manoj? They are at the end of the service. Your lordships will not. The order has not been.
Once we have
because otherwise we'll be out.
No, please. Look, we are. To us, makes no difference. We should grant it. But then we are bound by the precedents. If we don't accept it.
The 5 pieces, may I place that?
1 minute, please. Constitutional main judgment of Justice KL is very clear on that.
On this issue itself, there are 5 decisions.
That's what the impugned judgment does. It doesn't go into the distinction. It doesn't go into the distinction, but keeps on saying because they have been.
That is correct. Because notification does not make that distinction.
No. Please, that's not so clear. We have to go to the core matter rather than to go on peripheries. Don't do that.
Your Worship, may I make a submission? The short issue is whether or not a vehicle mechanic of Assam Rifles deserves to be paid the same as a vehicle mechanic of
No,
CAP.
please.
That's the
It's not so simple. Except in 1 or 2 cases, you see that when the entry level qualifications are different, then the constitutional bench judgment, which is binding on us, says there can be difference in pay scale.
Your Worship, as per the recent advertisement, I have that on record. If one counter of mine could be
Please, we'll have to answer that the chart which they have given by way of affidavit.
We'll do that. Your Lordship may not
Do that.
grant leave because lots
No,
of.
no, it will take time. It will take time. In the meanwhile, we give liberty to the respondents to file response to the chart annexure A1 attached to the written arguments with reference to the eligibility qualifications required for under the Assam Rifles and
CAPFs.
the central paramilitary forces, other central paramilitary.
Obliged, deeply obliged.
That the parity is there. Please give them.
I'll ask them. I
I'll always
understand
state that in the order.
I'll
Otherwise,
take
you won't
that-
have to always state that. Yeah.
Please take that on, look, wherever you find, don't do it.
I'll come.
At the same time,
Well,
we-
we'll not wrap it up.
no, please. At the same time, the additional Solicitor General who appears on behalf of the petitioner states that wherever eligibility norms.
Well, as I
So,
on record that I'm.
Please, okay, we are directing them.
Well, as I have to
At the
verify.
same time, we direct the petitioner to give pay parity to the members
Well, as
of the Assam Police where the eligibility norms are in the said force are equivalent or same
well, may I suggest?
as these.
No, I appreciate what is following.
Or should we direct that in these cases should be done?
No. Well, as
Malad, please do that,
hear me,
Malad.
2 seconds.
We have really been suffering.
Yes.
We've really been suffering, Malad. 33 years, one post, nothing has happened.
That, look, we don't, look, for to court, what you must get, you should get. Don't use the word suffering.
Malad, not just that. Malad.
Don't use the word
Law and equity, both
Please,
my respect.
none of the government servants, most of the government servants are very well paid.
Well, as the direction will lead to other claims that mine is actually equal.
Well, they are in
this
fact
equivalent is
accepted
equal.
in
Base, okay, then point out which are the ones you are saying are equal, we'll say.
Malas will take in. I'll do it, Malas. I'm saying this before this
Then
point, and I don't say.
When I was putting it with you, you say I don't do it.
No, I
When
will.
I say I'll issue directions, then you say I don't do it.
That I will take instructions and I'll get whoever there is equivalent will leave.
At the same time, we call upon the appellant to take a considered decision where they take a considered decision to ensure pay parity, where the eligibility criteria or norms for members of the Assam Police are identical
Assam
to
Rifles.
other central. Assam Rifles are identical to the Central Reserve Police Force. The said exercise along with the said exercise will be undertaken within 2 months, 2 months from today. An affidavit in this regard will be filed on or before 7th of March 2025.
Yes, but that would therefore dilute my stand on
Maybe
compromised and
you file a chart. We are asking you to file a chart, and you should realize.
on
1 minute, please.
my.
You look, you are not at list. You are not at. It's not an adversary.
Yes, I know that. That's why.
They are your workers. They are your. They help you. They do your work.
I'll take it. Right.
Listing it in March, then after that, for at least this compliance.
I've said March.
Yes, listing in also March.
We have directed listing in March.
KK Dinesan Lordship.
No, we are concerned. Whichever way it has to go, it must go.
My learned friends have got.
In the case of the Lordship, in the case of the KK Dinesan, this court has granted.
Don't worry.
Similarity Lordship.
Okay.
In Sarban Singh also Lordship.
Okay. We are bound by our own judgments. We can't watch it. So we want. We like certain.
Deeply.
Item 15, Your Lordship, the learned ASG is appearing.
Malad, I beg to appear, Malad, this is the OROP anomaly issue.
Here and now you've gone to the online
Malad,
mode.
I had to attend to another.
Okay.
Malad, we've taken a decision, Malad, and we have placed it on affidavit before Your Lordship, Malad.
Nothing has been supplied to us, my lord. I'm in 15.1, my lord. Your lordship has.
You're not going by that?
No, my lords, we have not accepted, my lords. We have not accepted the recommendations.
Okay. So what is the justification given?
My lords, I'll show that to your lordships. My lords,
Then this will have to be then challenged.
this will have to be challenged, my lords, if the respondents are aggrieved.
The earlier order had merely said that you please ensure that you decide within this and this time.
Please, my lords. But
You
my
have
lords,
to challenge now. You may have merit in it. I won't be saying that you don't have merit in it.
Can you appreciate, my lord? I'm in 15.1, my lord, where the applicants, my lord, have gone from AFT and the.
No, AFT, what did AFT direct? AFT, if I'm not mistaken, directed them to please take a decision.
Yes.
Lord,
I don't think AFT said that. AFT pointed out the anomaly and said that please take a decision. They did not go into the decision aspect. They did not examine the merits of the decision.
That's right.
Held the AFT order and had directed them, my lord, to take a decision, my lord.
Now the decision is taken which is against you.
Lord, the copy of the affidavit has not been supplied to me. I'm not in 15. My matter was tagged up.
No, please take this. You please take it. Please take it.
We'll give it to.
In fact, by keeping the matter pending over here, we are delaying your decision. If it has to be in your favor.
If your lordship can have it next week, can just go through it and have my submissions ready for this.
Union of India has filed an affidavit enclosing therewith the decision taken by them.
Quite a detailed one.
Counsel for the respondent presses some time to obtain instructions and make a statement before the court. Stop. Freeless next week.
Grateful.
Great.
I hope you didn't take a negative decision because the cost imposed.
No, my lords, there were 6 recommendations, my lords, and my lords, that made us take the decision, my lords, but I have brought a chart also to explain to your lordships that they are being.
Great.
So I'm seeking for a password, madam.
Grateful.
What is the issue?
Item 16, Senior Advocate K. Radhakrishnan is appearing. I'm just seeking a password, madam. He's on his legs in court level. Rastagir.
Is somebody there in item 36 and the supplementariness at West Bengal matter? No, both of you, all the parties are there, then we'll take it up, otherwise we won't. Because that's a big chunk. It's large number of persons who are affected. Otherwise, if they're not there, then we'll take it up next Thursday. 36, you say, next Thursday to be listed in first aid cases. 16. So much.
16 minutes. I place your horses. And for the petitioner. Now minutes, the council in Annexure 37 on page 193 has recorded that the conciliation has failed.
Page?
193 minutes. In fact, 189 Annexure P37 commences at 193, Your Lordship will be getting in the first paragraph of 193, since the at last sentence of the paragraph.
The impugned judgment first.
Mr. Sarawat, impute order. Paragraph 7 may kindly be seen. Page 57. Paragraph 7 of the impugned judgment. Paragraph 7 of the impugned judgment.
The impugned judgment must have been filed subsequently because it was not there initially.
Facts, sir. Yes. As paragraph 2 narrates the facts. Separately produced. This one. That's okay. That's paragraph 2 of the impugned judgment. It was separately produced minutes along with an interlocutory application. At the time of filing the SLP, it was not.
Yes, please.
The facts in brief leading to the filing of the instant appeal are as follows. Pursuant to the tender notice published on 27/1/2010 for design, supply, erection, and commissioning of 2 numbers of ESP for clinker coolers at Ariyalur Cement Unit on turnkey basis, the Appellant Corporation, after discussions with the Unicorn Engineers, Coimbatore, the second respondent herein, on 16/4/2010 issued work order to the second respondent company for execution of the aforesaid work, and the same was accepted by the respondent company. On 16/11/2013, the Appellant Corporation sent a letter to the respondent company requesting to complete all the works before 30/11/2013 and analyze the cause for higher dust emission than the estimated level during unstabilized operation of the kiln and sold the same. The respondent company has filed an affidavit before Micro, Small and Medium Enterprises Legislative Council, the first respondent herein, claiming an amount of so and so under various heads. The appellant sent a letter to MSE citing various issues faced in ESBs supplied and commissioned by the respondent company, and also stated that they had supplied and substandard spares. On 27/5/2014, the appellant sent a letter to the respondent company to attend the problem in insulation cladding in ESP2. However, the respondent company refused to rectify the issues, stating that they had already filed a claim before the council and warranty period was also already over. Hearing was held before the council on 14/10/2014. The respondent company was directed to produce documentary evidence for the materials, theft, missing, damaged items as per the list produced, and also directed to set right all the teething problems. The appellant was also directed to permit the respondent company to carry out all the rectification works. The first respondent council, upon hearing both sides, passed an arbitral award holding that the appellant corporate...
The arbitral award was passed by the the council itself. The arbitration award was passed by the council itself?
No. There was no award passed by the... It is not an award, it's a conciliation.
1 minute, please.
Conciliation.
1 minute. According to you, it's not an award.
No.
What is it?
The first, that is what I showed to your lordships at Annexure 37. Annexure 37, the order at Annexure 37 of the impugned judgment.
Just 1 minute.
Sorry,
Just
in
close the
the
mic.
paper book.
Just come to page.
Annexure 37 may kindly be seen, 4/6/2016. It is not an award, my humble submission. Award and the order are different. (76B minutes). Arbitration. So my humble submission is that this is not an award. At annexure.
Read further, let's read further. Read further from the.
I shall, sorry. The first respondent council, upon hearing both sides, passed an arbitral award, holding that the appellant corporation.
I don't think we'll be able to take up any more matters after this. Please. This will be rolled over to next Thursday. Yes.
Holding that the appellant corporation is liable to pay balance retention amount of so and so, along with the interest due to piecemeal releases of the total retention money of so and so with effect from 31/3/2011 and so and so along with interest with effect from 17/1/2014 towards additional expenditure incurred by the respondent company due to the delay of 3 years in execution of civil works by the appellant, or together with a compounded interest with a monthly rest at 3 times of the bank rate notified by the RBI as stipulated in MSCD Act 2006 from appointed due dates respectively to the second respondent company till the date of settlement. On 19/9/2016, the appellant filed a petition under Section 33 of the Arbitration Conciliation Act 1996 to recall award in case number so and so dated 4/6/2016 by order dated 25/10/2016. The first responder rejected the recall petition on the ground of delay in the filing of the recall petition and also on the basis of objection made by the respondent company. Thereafter, the respondent company has filed execution petition number 7 of 2017 for claiming an amount of so and so with interest as awarded by the first respondent council via the impugned order number so and so, and the appellant also filed its counter. On 4/1/2017, the appellant has filed OP number so and so, challenging the award passed by the first respondent in case so and so. In the meanwhile, the appellant challenged the powers conferred by Section 16 to 19 of the Act 2006 in writ petition number so and so. Along with the writ petition, the appellant also filed miscellaneous petition to stay all further proceedings pursuant to the.
What is the reasoning given in the end?
Beg your pardon?
What is the reasoning given in the end? What is the core of the reasoning given by the High Court?
I'm extremely sorry, I didn't get your
What is the reasoning given by the High Court?
reasoning.
Can we come to that portion?
Because I have made 3 attempts, that is under 33, 1, and now under 34, 2, and this is the 3rd attempt.
No,
I
you went
cannot
under
give any
34
appeal.
2 also? You went under 34 2 also? You lost?
That was withdrawn, Millers.
That was withdrawn. Why?
Because it is not an award, that is why. Because I filed the petition under 33 for recalling, and that was dismissed on the ground of delay only. And then the other case was also attempted, that was also withdrawn. I have stated the same.
Okay, let's read the reasoning at page 18.
Here.
Page 18.
18 minutes. We have heard the decision of counsel appearing for the appellant and so and so. All the aforesaid litigation arose out of the award passed by the first respondent counsel dated 4/6/2016. The first respondent, upon hearing both sides and placing reliance on section 15 and 16 of the Act, passed the impugned award dated 4/6/2016, and the consequential impugned order dated 25/10/2016 has been passed by the first respondent counsel. The main ground raised in the instant writ appeal by the appellant is that when the impugned order is presumably under section 76B of the Part 3 of the Arbitration and Conciliation Act 96, for failure of conciliation proceedings, the same would not amount to arbitral award under Chapter 6 of the Arbitration and Conciliation Act, and therefore not enforceable. This is our contention, Millers, legal contention. And section 18(4) of the Act 2006 makes it clear that notwithstanding anything contained in any other law for the time being in force, the counsel or the sender providing alternate dispute resolution services shall have jurisdiction to act as an arbitrator or conciliator under this section in a dispute between the supplier located within its jurisdiction and a buyer located anywhere in India. 19 of the Act deals with the application for setting aside any decree, award, or order made by the council itself or by an institution or sender providing alternate dispute resolution services to which a reference is made by the council shall be entertained by the court, provided the appellant has deposited 75% of the award amount. It is useful to rely upon the earlier order passed by this court in OP number so and so dated 9/9/2021, filed by the appellant challenging the award passed by the first respondent counsel dated 4/6/2016. In the aforesaid OP, the appellant elaborately argued before this court, and this court, by relying on various decisions of the Honorable Supreme Court as well as this court, dismissed the OP holding that the first respondent counsel itself invoked arbitration proceedings, though counsel has not followed the procedure contemplated under the Act. That cannot be gone into when the application itself filed under section 34 of the Act is not maintainable because before this court. The relevant portion of the aforesaid order reads as follows, quote, "The matter has been referred to by the first respondent before the council on a dispute arising out of the outstanding payment payable by the petitioner. The petitioner engaged the first respondent for erection and commissioning of clinker cooler at cement works in the premises of the petitioner corporation. The reference was made for the principal amount so and so, and then subsequently all the amounts merits can kindly come down. Now the only issue raised before the council is a question with regard to quality of ESP. As the conciliation is not materialized, the matter has been referred to council, and the council has passed the award, which reads as follows. The respondent shall be liable to pay the balance retention amount of 39 so and so. Then the amounts are indicated there till the date of settlement. That is a paragraph. Now, unquote, 17. Section 33 of the Act cannot be invoked to set aside the award or to recall the award, whereas the application filed in the given case is only in the nature of first appeal before the Council, and the same has been rightly rejected by the Council on 25/10/2016. Having regard to the above legal position and the provisions of law itself makes it clear that the application under Section 34 of the Act to set aside the award cannot be entertained unless it is filed within a maximum period of 120 days as provided under Section 34 of the Act. Insofar as the award of the Council, it is the contention of the petitioner counsel that as the conciliation is not rectified, the second respondent counsel itself invoked arbitration proceedings, though Council has not followed the procedure contemplated under the Act. That cannot be gone into when the application itself filed under Section 34 of the Act is not maintainable before this court on the ground of limitation. Such view of the matter, both the original petitions are dismissed, consequently connected applications also closed, unquote. In the aforesaid order dated 9/9/2021, passed in OP number so-and-so, the contentions raised by the appellant have been elaborately discussed and finally rejected the claim of the appellant. Challenging the order dated 9/9/2021, passed in OP number so-and-so, the appellant has preferred an appeal before this court in OSA number 55/2022, and the same was withdrawn by the appellant on 28/4/2022. It is pertinent to note that this court, while dismissing OP number so-and-so, has observed that the second respondent counsel itself invoked arbitration proceedings, though counsel has not followed the procedure contemplated under the Act.
Let's see the award passed by the council.
That is what Annexure 33.
Page?
Page 189. It is the Annexure 37.
189.
Annexure 37. 188. It commences minutes of SLP. I hope my notes are there.
Yes.
189. Sorry, my apology. Annexure 37. My lords can directly come down to 193. 193.
Yes.
The last sentence of the first paragraph, Lordship will be getting, last sentence of that. Since adequate opportunities were given to the respondent, the council recorded the failure of conciliation between the petitioner and the respondent. I hope your Lordships are seeing that. Now, after that, Lordship may kindly see, in view of the above facts and circumstances, the council ordered that the applicant is free to approach the council for arbitration as conciliation between them has failed. Now the council is going to section 15, section 16, extracting the same minutes. Lordship may kindly see on to page 194, the council directs the petitioner is entitled to recover the balance retention amount of so-and-so, so-and-so. And in the next paragraph also. My humble submission is that this is a strange,
Okay, show us the MSME Act.
MSME Act, Lordship will be getting, kindly see page section 18.3. A reference to Micro and Small Enterprises Council, Facilitation Council, 18.3 may kindly be seen. There is an amendment also, and it's in subsequent that was brought in 2019 or so. Section 18. I hope your Lordships are on 18.3 before the amendment.
Okay, we got it.
18.3 before the amendment minutes. The amendment was in 2023. The amendment was in 2023. Now 18 reference to Micro and Small Enterprises Facilitation Council. Notwithstanding anything contained in any other law for the time being in force, any party to a dispute may, with regard to any amount due under section 17, make a reference to Micro and Small Enterprise Facilitation Council. Now, on receipt. Magnus. On receipt of a reference under subsection 1, the council shall either itself conduct conciliation in the matter or seek assistance of any institution or sender providing alternate dispute resolution services by making a reference to such an institution or sender or for conducting conciliation, and provisions of section 65 to 81 of the Arbitration Conciliation Act shall apply to such a dispute as if the conciliation was initiated under part 3 of the Act. Now, minutes. Now, kindly see 18.3 minutes. 18.3. minutes. When the conciliation initiated under subsection 2 is not successful and stands terminated without any settlement between the parties, the council shall either itself take up the dispute for arbitration or refer it to any institution or sender providing alternate dispute resolution services for such arbitration and the provisions. So arbitration minutes is an adjudication. And that is not taking place in Annex 37.
There is bench decision against you.
There is a judgment in my favor, minutes, of your lordship's judgment.
Which judgment?
I shall take your lordship's to that.
No, you are aware of the 3 judges bench decision?
You
are aware of 3 judges bench decision?
I have not seen that. Sorry, minutes.
Why? Which is that judgment, Mr. Om Prakash?
But it is in India Glycols Limited and another versus MSME. 2023 SEC Online SC Millard 1852.
Sorry.
It overrules this decision.
Sorry, minutes. So, I overlooked this. Sorry, my apology.
It overrules 2 decisions, earlier decisions.
But yes, minutes, yes, I bow down. But at the same time, my submission on the face of Annexure P37, lordships can see that there is no adjudication that is taking place. An adjudication is necessarily to be conducted by the council of by itself or by another body in an arbitration proceedings, in which event I can present my case, the other side can present its case. That is not taking place here. The conciliation has failed. The council has noted the same and also directed you can go for arbitration. Now, what is the purpose of going beyond that in traveling to section 15 and 16 and then directing me to deposit this much of amount? That is why your lordships have passed an interim order. And we have already deposited around 4 crores more.
How much have you deposited?
Further, petition has already deposited 4.41 crores. And out of which
How much is the awarded amount?
1.5 crores has been released to the respondent number 1.
What do you say? The Doesn't this strictly require some reconsideration? India Guy call. Does India Guy call require reconsideration?
India Guy call,
Yes.
Because I would respectfully submit no.
Why?
In the fact of this case, it may not arise. Because in the facts of this case,
there is no award, in fact. There's virtually a.
Both parties, with great respect, treated it as an award. They filed a 33 first. The problem there is the 6-year time lag. Which
As far as I understand, by subject to correction also, right? 226 is never taken away. 226 power is a statutory arbitration.
Maybe, but your lordship may consider the lag.
And also read 18.2. And under section 80, normally read 18.2 of the MSME Act.
On receipt of a reference under subsection 1, the council shall either itself conduct conciliation in the matter or seek assistance of any institution or center providing alternate dispute resolution services by making a reference to such an institution or center for conducting conciliation and the provisions of section 65 to 81.
Now read section 80 of the Arbitration Conciliation Act.
Role of conciliator and other proceedings. Unless otherwise agreed by the parties, conciliator shall not act as an arbitrator or a representative of or counsel of a party in any arbitral or judicial proceedings in respect of a dispute that is subject of the conciliation proceeding. Conciliator shall not be presented by the parties as a witness in any arbitral or judicial proceedings.
Full opportunity of hearing.
Because now in 18 laws, 18.3 if your lordship sees, 18.3 where the conciliation initiated under subsection 2 is not successful and stands terminated without any settlement between the parties, the council shall either itself take up the dispute for arbitration.
Now we'll have to interpret this whether in this case whether the same persons can act as an arbitrator who are acting as a conciliator. One. Number two, 18.2 also says the council may take up itself or may refer it to any other person.
Yes.
So we'll have to reconcile it. That's not been examined.
Well, maybe. I'm just trying to point out a distinction in the facts of this case, Manoj. That's what.
What's the distinction here? No statement of claim is called.
No, Manoj, the conduct of the petition, Manoj, they have treated it as an award. They first go file.
Forget about it. Look, there's no estoppel against law.
No, I'm only saying the lag.
Look, please, it's not in India. If we apply that, unfortunately, I don't want to say that, but the fact of the matter is legal guidance and advice sometimes is lacking here. No, we can't be oblivious. That's why, unlike most of the countries where you're not allowed to take fresh pleas in the appellate forum, they simply bar you. You can't take a new plea from the appellate forum. They say if you're not taking the plea, go home. That's it. Here we permit it because of that issue.
No, that's true. But the problem is the act itself was created.
We'll have to reconsider. We have to apply it.
No, may I just
point out? Reserve the judgment. We'll see what is to be done.
May I just point out what Lordship, they've already had 4 shots at the award. This is the fifth time they agitated.
There is no award according to them.
Is it an award in the first place?
No, they have treated. They have
18 of the arbitrator.
When you're treating it, they do not confer the status of it. Legally, it should be an award.
Why are you arguing? We are putting the questions to them.
My apology.
There is a 6 year delay in filing the award. Let me say the order of the council is 2016. They filed the petition only in 2022. No, they filed a 30-40, they failed.
I know that.
But may I only add 2 points, but.
Yes.
But this is almost the 3rd petition. But at the 34 level,
please, this will not even stand the execution proceeding probably.
No, my lord, at the first instance, when they came before this honorable court, this wisdom was not there for them.
Sir.
Even a pre-deposit was challenged by them before this honorable court.
Okay. Argument, sir, judgment. I don't know. Let's see what we'll do.
Just one, in case lordships are allowing it, the matter will then have to go to arbitration. Your lordship may refer it to the Madras High Court Arbitration Center.
No, we pass an order. We want to pass an order. If you're conceding to it, we can pass that order.
No, I'm only saying that I don't have to disturb your lordships at a later stage. Just in case you're not
Sure,
sure.
we'll see what to do. Thank you.
The other matters will be retained on the
Thursday.